Please, Lordship, in item number 23, my lord, I have filed objection, my lord, on behalf of the informant, my lord. That may kindly be permitted to be
23,
taken.
from the informant side.
Yes, my lord.
Anyway, case diary is received.
My lord,
Okay, we'll call.
May I please, your lordship?
Objection, they said 23. Yes.
May I please, your lordship? Item number 11, lordship. Today I have some personal difficulty, lordship. This matter may come after a week, lordship. I have informed amicus curiae also.
Mr. N. Mahajan was as an amicus curiae.
I have informed him.
Consent. Appellant MS S. Kanungo. 8.8. You want any fixed date here or after 2?
8th, lordship?
Huh?
8th May
Let us see. You have to see.
or 15th.
15th of May.
May I please, your
Yes.
lordship, beg to mention item number 17. The English counsel in Hassan, he is not in position to appear today. So can it be fixed on
We
4th?
have received
May?
this scan copy here. Yes. Scan copy have we have already received.
Yes, yes.
You have some personal difficulty.
They actually engaged.
Mr. Hassan.
Yes. Can it be fixed on 4th or 5th of
On
May?
the behalf of Mr. N. Hassan, the English counsel. The terminal is paid for. Prayer out. However, this scan copy of the decision already been received. Estimate. 4th of May.
Please.
May it please, your lordship. Back to mention item number 29. Item number 29.
29.
29. The conducting counsel is unable to conduct the matter today due to some medical difficulty. So date may be fixed on the first week of May, Lord.
29. What is the position of 29?
Lordship, is there. CD was called for in the earlier occasion, Lordship.
We have received the CD.
No, Lordship.
In pay may continue.
CD not received.
Let it be on 8th of May, Lordship.
It is reminded it should be continued with next set of list. 8 of May. Okay. 8
In pay may continue.
interim we are continuing in.
Not bad.
May I please, your lordship? I beg to mention item number 28, lordship. CD was called for is not received, lord.
What is the position of 28?
Success has been filed, Lordship.
Charge sheet file.
Yes.
Are you on interim there?
Lordship.
Yes, your lordship.
You are on interim.
Interim, Lordship.
So what we'll do, we extend your interim up to 15 days with a regular bill application approach the learned trial court, and case will be accordingly disposed. What is this CS number?
Lordship, charge sheet number byte 61/2026, dated 29/03/2026.
I don't know. You are MS
And a big.
and a big. I'm not included on Kurva, third MS SH Paradil edition. We are extending your interim up to 15 days. Okay.
Obliged.
Yes, yes. With the consent of the other side, I beg to mention item number 9. Unless this matter is ready for disposal, well, today some difficulty may appear for on 12th May. Hearing them, affidavit file, ready for
Government
disposal.
advocate was there. Have you informed the other side? No.
Yes, yes, it is. Item 9. WP criminal. On 12th May.
Consent of the other side. Your name is not here?
No, my lord, on behalf of Mr. S. Bhattagola.
As Botakur or behalf. On behalf of Mr. N. You are Mr. Gogoi, na?
Lordship. You.
T. Gogoi, heard Mr. T. Gogoi appearing on behalf of Mr. N. And with the consent of the other side, stating that there's some personal difficulty on the part of the NPS council, Mr. Bot. You're saying when?
On 12th May.
1-2.
Or 1 to Lordship. Hearing them, disposal. Lordship.
12th of May.
Lordship. Deeply obliged. May I please, Lordship? Lordship, I beg to mention item number 38 and 39. Lordship, this matter may kindly taken at 2 p.m. Lordship.
38 and 39.
Yes, sir.
Just a second. What is the position of 38 and 39? Available. At 2 p.m.?
Yes, Lordship. Lordship.
We'll take up the matter at 2 p.m.
May it please your lordship. Lordship, I beg to mention item number 30. CD was called lordship, but CD has not been received yet. Lordship
Yes,
may
what is the
fix this
position of
matter
party?
on 6th.
CD not received here. Are you on interim?
No, Lordship.
They are not on interim. It did not receive, issue reminder. Yes, when it can be called fixed,
Lordship,
they are not on interim.
first week of May, Lordship.
6th May, Lordship.
Sixth. Oh, sixth. Interim 9 days.
May I please, your Lordship? Lordship, I'm praying for an urgent listing of a matter. Lordship, matter is very, very serious matter. A students of
Like I
Royal.
mentioned before, court number 8.
My Lordship,
Court number
Senior
8.
bench.
Vote number 8.
Senior bank.
May it please your lordship, I beg to mention item, item number 32 of the daily list. CD was for call for perhaps that has not come.
Are you on interim?
Yes, I'm on. the lordship.
They did not receive, issue reminder.
On 12th of May,
Pardon?
12th May, Lordship.
Lordship, can it be on 18th May?
18th.
18th May.
18th of May. Interim be continued till next day.
Deeply obliged.
May it please your lordship. Lordship, I beg to mention item number 25. Lordship, due to some personal difficulty, my senior would be able to appear for this matter today. So matter may be kindly listed on 6th of May.
35, Lordship.
No, she is
25.
35 or 25.
25. 25.
Can copy you have received that?
Yes, we have this.
That is.
The request made by the learned counsel waiting for the petition. Matter is that. However, this can copy of the DCI has already been received. It's the matter accordingly on with the delivery. Maybe.
Can it be on
11th of
6th of May?
Oh,
Highly obliged.
May I please? Well, I beg to mention item number 43, madam.
43.
Can copy of PCR call for that is received as per cause list, madam, but POXO is there. Notice issued to the private respondent, madam. Probably it is also served. I'm paying for my case, madam. Whether inspection available or not,
We have to call for it, then when it will be called for, then only you make submission.
my lord.
Let the matter be called for. We are not saying anything.
My
We
lord.
have to see the record. And
My lord. May it please, your lordship. I beg to mention anticipatory bail application 3465 of 2026.
listed today.
No, not this.
Make a mention before court number 8,
Court number.
senior bench.
May I please, your Lordship? Lordship, I beg to mention item number 14. On the last
1-4.
1-4. On the last occasion, the CD was called for. I believe that has not come.
CD not received, Lordship.
Lordship, may
It's a
kindly.
criminal petition. No?
Yes.
Criminal. Lordship, may kindly fix it on 7th of May.
The name is not reflected here, Mr.
I'll be led by my senior, Mr. Didas.
You are only Fukon or found also?
Count.
Count.
Only count.
Part Mr. Y count. The learned counsel appearing on behalf of Mr. D. Das, the learned senior. And also heard Ms. S.H. Bora, the learned additional PP appearing on behalf of children. It is submitted by Ms. Bora that she did not receive which will be required for disposal of the evidence. In view of this, let the CD be called for issue reminder. Yes, and where from where it has to come? From where it has to come?
Item number.
Item number 1414.
It's,
Yeah.
it's from your PS case, Lordship.
Where it can be listed.
Lordship, can it be on 8th? 8/5?
8th of May.
Yes, Lordship.
Much obliged.
দুটা division basis number basis দিনই। Single bench এর কি আছে? ও কিন্তু এটা division bench দুটা কথা না হয়ে যায়। ও এখানে এনে আই। Yes,
May I please? If the petitioner hearing is behind the bar since 12/11/2025, that is as of today, 163 days. The matter is also been charge sheeted and also charges has been framed herein. And the last date has been fixed for evidence or no PWs has turned up. And next date is also fixed for PWs. Okay?
When the next date,
Scan copy of TCR will be.
Now it
next
is
date on when?
on 30/0/04, on 30 of this April. So, Lordship, my humble prayer is that since the charge has also been framed and the evidence stays, there is no chance of hampering and tampering of evidence. So he may be allowed to go and bail and take a counsel of his choice so that he can fight his own case. Your Lord.
103.
Yes, Lord.
Yes,
One,
Captain.
two, three.
Scan copy of TCR will be required.
Scan copy of the PCR along with the CTP call part. Rest you will do the needful. Next date is your 34.
30/04.
We have let the matter be fixed after 34 because
Yes,
there may
yes.
be evidence record. If
Lots.
evidence, any evidence is record is good for you also.
Yes.
So, it will come from which place?
From Nogam.
From Nogam.
Rupohi Hattons.
No, it's a certificate.
Considered case.
No.
It will come from the Honorable District Judge Nogam.
District Judge. 6th of May, he's saying. 6th of
Obligation.
Please, Your Lordship. Let's CD may kindly call for Your Lordship with a pair of short date Your Lordship,
Along with the injury report.
injury report.
CTP call for along with
Total
the
36 days in custody Your Lordship.
injury report. Yes, Bora, when it
Lordship, can it be on 7th?
Mr. Karim, 7th.
7th of May.
Obligation.
May it please your lordship, charge sheeted bail, your lordship, behind the bar for 215 days, Lord.
2-1.
215 days.
Scan copy.
Charge has already been framed.
Yes, lordship. It is at a stage of evidence, lordship. Scan copy of PCR, I recall.
Scan copy of the TCR along with the case diary be called for. Rest you will do the needful. Estimate recording. 7/5 can.
Lordship.
7th of May.
Obliged.
Match comes. What is the Chief Justice of India, Supreme Court judges, or আমার আমার যা এটা কমকে লিস্টিং করা তাহলে কেতিয়া দাম গরু লাগিব বাথরুম নাই তাৰপিছত ডিনাৰ কাৰণে কি আমাৰ কিমান হ'ব এইটো? And appears on call for the petition. List matter accordingly after 1 week as an due.
May I please also 482 application also. The FIR is in page 13. The petitioner, his name is Orup Goswami, and the FIR name person is Orup Sharma. Just because of mistaken identity, the police is searching for me. That's why I have to come before your lordship. The petitioner name is Orup Goswami. Page 14, your lordship will find name of the miscreants in the last portion. Serial number 8, Orup Sharma. That's because my name is common, so police is searching for me.
There is no father's name is not there.
Not there. Nothing is there. Even the address is also not there. So I pray that lordship will grant me entirely appear before the police.
So why police is searching for you then?
Because my name is common, Orup.
You're from the same locality.
Somlikul. That's why. Because of the name. For namesake, police is searching for him. Lordship will kindly protect me. I'll appear before the Ayub and give all the relevant documents also.
Yes, Bora, what was
Lordship, Here the accused number 8 is Orup Sharma
Yes.
and present
That's
petitioner
what
is
he's saying.
Goswami.
Or Sharma.
Yes, Lordship.
So why you are apprehending that?
Yes, that
The
is the reason.
police has come to my house searching for me. That's why.
How
I have
it's
stated in my
connected,
petition.
that is not.
That's why, because of the name. Confusion is relating to the name. But the titles are different, even the address, father's name is also not there. So because of mistaken identity, police is searching for us.
Let us call for the case study shorted may be given, Lordship, Kamrup Metro itself. Sir.
Yes, sir, protection should be given. I
Not-
think
I'll
because
appear before that.
if he is not the person.
Not.
then
And if anything
we
found
had-
against him,
If
then
if it is, if materials are there, then you'll also reject it later. Suppose,
How can we know materials you are?
no, after diary, after diary.
So I'm
No,
insisting
after
on calling
diary.
for the case
Your
study.
father's name is Sharma, no?
No, Goswami.
You also Sami.
Goswami Lordship. Tarini Goswami.
Heard Mr. Dita Lutin, the Daniel counsel for the petitioner, also heard him as SH for the Daniel condition bring on the upstairs. This is an application section Swensson, condition Swensson. It is submitted by Mr. Tampa, the representative petition. No way, petition, accused being the representative petitioner is no way carrying the alleged offense. However, as per the FIR, the name of the name of one accused is accused number name of the accused number 8 is mentioned as Arup Sharma, and the name of the present petitioner is Arup. As there is similarity in the name, the police is searching for present petitioner with a mistaken identity. However, he is ready to appear before the IO and to produce all relevant documents and accordingly paid for some information. Mr. MS Bora did an additional people submitted. That CD may reveal the actual fact of the case and also the identity of the accused may also be may also be reflected in the case. Considering the submission made by non-consumer goods, let the CD be called saying so and so, and lucky and then are they, and also considering the entire circumstances, no, the submission made by so and so interim. Okay, you will be under interim protection, appear before the IO
That's
and submit all the necessary
relevant documents.
relevant documents for your identity.
That's
Yes.
Diary.
When it can be
On
listed.
12th of May.
Lordship. March.
Mac Major Lordship, this is a 3 years bail Lordship. The FIR lodge is a complaint before the judicial magistrate Lordship. Page 17 is the FIR Lordship. The crack of the matter is that Lordship, the present accused person are the member of a NGO. Lordship, they have introduced a lottery system with a promise to deliver them prize and awards Lordship and for the development of that particular area. Now what happened Lordship, that continued. And the person, Lordship, the complainant with the agent, Lordship. They used to sold the tickets and used to collect the money and then they were supposed to deposit it in the NGO office, Lordship. The thing is that they have not deposited the money, they have misappropriated the money. When this accused person, the member of the NGO, put pressurize upon them, they have lost the FIR saying that we are not giving the gifts and money as promised by us during the introduction of the lottery tickets Lordship. Now what happened thereafter, they have went to police station. And police station, when made an investigation, they came to know that this person are the agent, they are the agent and they have misappropriated the money, so they refused to register an FIR. Thereafter, they have approached the Chief Judicial Magistrate Court for registering a FIR, where they have clearly stated that they have approached the police station, but they have refused to register a case. The refusal is reason that they came to know after investigation that they were the agent and they have misappropriated the money of the lottery. They have not deposited to the NGO. That I have already categorically stated in the my petition Lordship, that on paragraph Lordship 5. I have categorically stated the fact that the petitioner begs to state that they are innocent once falsely implicated in instances. The actual fact of the case, the petitioners are the member of the NGO, namely so and so, said NGO launches conduct a lottery gift cards and different dates meant for social welfare, including assistance to the disabled student. The complainant are agent who sold tickets. The complainants are the agent who sold tickets, but they did not pay the entire ticket sold amount to the NGO. When the complainant were asked to pay the amount collected, various person otherwise action would be taken against them. They failed complaint to save their skin. And in that complaint itself, they have stated that they have approached the present complainant, they approached before the police station, but they refused, police refused to register the case, Lordship. That's Lordship. That on page 26, Lordship will kindly see. Page 26. Page 26, Lordship have found 26. Paragraph 13, Lordship, that being agreed on 20 of the complainant approached the Dompara Outpost Police Station and the later Manikpur Police Station respectively to lodge an FIR against the accused person. But the police authority refused to register the case. Then second paragraph, the complainant also submit a written complaint before the Superintendent of Police Bongaigaon on 13/11, but no action was taken till date, Lordship. This is the reason they did not register, because they all know that every villager told that they were the agents selling the tickets, Lordship. And that person were also called in police station, the accused person, they were interrogated there when they told that the money were not received. That is known to everyone, Lordship. And thereafter, without finding any alternative, they have approached the court and court directed to register a case, Lordship. My humble prayer, Lordship, let us appear before the IO, Lordship. We are not running away with the reputed person of that society, Lordship. We are running an NGO, Lordship. Only
Yes,
now police also in
Lordship, page number 25 of the petition, it is reflected that on several occasions, the complainant approached the accused persons to refund the amount. But they have not only refused to refund the money, but also criminally intimidated the accused persons. And thereby, Lordship, they have tried to harm the reputation and property of the, as per allegation, Lordship. And to that regard, Lordship, village meeting was held on 25/08/2025, where the accused persons has assured the complainants to refund the money, but same has not been done. And thereafter, Lordship, due to non-payment from the state side of those persons, they have filed a petition before the court, Lordship.
and to
So let
contest
us call for the case diary.
to the submission of the Lane PP, I'll try to page 26, Lordship will kindly see. Page 26. Everything has been annexed, Lordship. 1, 2, 3 lottery ticket coupons. Annexer 5 is the money receipt of the same complainant. Annexer 5, 6 are the Azahar. 7 written complaint addressed to SP Bongaigaon. Annexer 7, the postal receipt, and Annexer 9, the tracking consignment, not the minutes of the meeting, Lordship. Why? Everything has been given, Lordship. A total 9 annexes were given in the complaint petition. Why not the of the village meeting, which my Lanet PP has pointed out before the
CDM
court?
will reveal everything.
But till then, Lordship, the
Let us
police
call
also
for the case diary, Lordship.
till then, Lordship, the complaint itself clearly says, Lordship, police 2 times not registered the case,
Public
Lordship.
money has been siphoned.
No,
Lordship.
they are the agent, they have not deposited us the money. From where will refund the money, Lordship? When we pressurize them, Lordship, they have done this step, Lordship. But village meeting was also organized by us.
Additional PP appearing on respondent. Snap petition. Next, submitted by Mr. Moni the and there the members went NGO where they used to pay lottery tickets and coupons, and the money earned from those coupons were used for social activities, including benefit development for some students. But the present, the complainants, they are some the agents whose duty is to collect the money and coupon from the various persons and to deposit the amount to the NGO for their disbursement. But instead of giving returning the money, but this is not okay. But when the money was, but they have not deposited any money which were collected from the various persons. And when the money was, when the NGO asked for return of the money, they lodged a false complaint initially before OC of the concerned police station and subsequently before SP of the concerned district, but those were not entertained, for which complaint has been lodged before learned CTM with some false conclusions. However, the petitioners are ready and willing to extend their cooperation in the investigation of this case and also ready to submit all relevant documents as if required during investigation. If required during investigation, if some interim protection provided to the present petitioners. So, next point, MS Bora, the learned Section PP raised objection and submitted that it is a public money, the allegation act for a misappropriation of the public money, and hence the EC insisted to call for the CD to know the actual fact of this. Here is a submission made by learning considering all aspects. This court is of opinion that some interpretation may be provided to the present petitions. Yes, okay, will be provided with some interim.
So, Lordship, 8 persons are there.
When it can.
Lordship, can it be on 14th of May? Interim.
Oh, thank you. Much obliged, Your Lord. Much obliged. Much.
Yeah, please, my lord. My lord, prayer for PRS bail application, my lord. The page 16, this is the FIR, my lord.
Page 16.
Page 16. Vernacular.
Yes.
May I read, lordship? Mahoday. এজাহাৰকাৰী বিনীত নিবেদন এই যে অধীনৰ চিলাপথাৰ থানাৰ অন্তৰ্গত ওৰফে ঠিকনাৰ দৰিদ্ৰ সীমাৰেখা তলৰ স্থায়ী বাসিন্দা উপৰোক্ত অপৰপক্ষই আজিৰ পৰা কিছুমাহ পূৰ্বে ফোনযোগে চিনাকি হৈ মোৰ সৈতে মোৰ সৰলতাৰ সুযোগ গ্ৰহণ কৰি যোৱা ইংৰাজী ৬ তাৰিখে তেওঁ নিজ গৃহলৈ ফুৰাবলৈ বুলি নি অতি চলাহী কথাৰে মোক বিয়া পতাৰ প্ৰলোভন দি মোৰ ইচ্ছাৰ বিৰুদ্ধে মোৰ সৈতে বলপূৰ্বকভাৱে শাৰীৰিক সম্পৰ্ক স্থাপন কৰে মই প্ৰথম অৱস্থাত তেওঁক বাধা দিছিলোঁ যদিও তেওঁ চলাহী কথাৰে ভুল গৈ তেওঁ আৰু পত্নীৰ মৰ্যাদা দিয়াৰ প্ৰতিশ্ৰুতি দিয়াত তেওঁ ঘৰত মই থাকিবলৈ সন্মতি দিওঁ This line, Your Honor, is crystal clear, Lordship. There are 2 adult person, Lordship. It's a consensual relation. The next. এতিয়া তেওঁ মোক পত্নীৰ মৰ্যাদা প্ৰদান নকৰি মোৰ চলিত ধৰি তেওঁ ঘৰৰ পৰা খেদি পঠাই সি মোক বহুদিন বিভিন্ন সময়ত মোক পত্নীৰ মৰ্যাদা বিচাৰিলেও ডিঙি চেপি হত্যা কৰাৰ চেষ্টা কৰাৰ উপৰিও ঘৰৰ পৰা গুচি নগলে প্ৰাণে মাৰি পেলাই মৃতদেহ পেলাই দিয়াৰ ভাবুকি প্ৰদান কৰি মই প্ৰাণৰ ভয়ত ৬ তাৰিখে তেওঁ ঘৰৰ পৰা মাতৃগৃহলৈ ঘূৰি আহিবলৈ বাধ্য হওঁ This is the FIR. As FIR, Lordship, the register under section 87, 64. 87 is kidnapping and abducting. This FIR, it is clearly there is no abducting or kidnapping. And Lordship, this another section is the 64. This is punishment for rape. There's no rape, Your Honor. As FIR, it is clearly, this is also other remedies available, Your Honor. The section 9 of the HMA, Hindu Marriage Act, it is a file a petition, Your Honor, restitution of conjugal rights. This FIR, it is clearly stated that they cannot.
Who will file restitution of conjugal rights?
No, Lordship. Never file. Both the party never file. But other also, the open the door, Your Honor. As FIR.
There is no marriage, how restitution of conjugal rights?
There is a marriage within 3 months already in petitioner in house, Your this matrimonial house,
Yeah.
maybe.
We
Other
want
also
to say
remedies
that
available.
the
And now, Your Honor,
conjugal rights will lie there.
it is a, yes, it is correct, Your Honor. And other is, this present petitioner is a police constable, Lordship.
It's a government servant and responsible. It's a job, Your Honor. He protecting us and every citizens of the enemy of the state.
Who protecting us?
This person, yes, it's a police constable, Your Honor.
Could not
It's a-
protect himself.
No, Lordship. Lordship has, it's a duty, Lordship. It's a duty.
Obviously, duty.
Yes, it's a duty, Lordship, and maintaining law and order. Will cooperate, Your Honor. Will cooperate. Petitioner is not quite risk, Lordship. Will cooperate. There's no,
Yes,
he has no criminal
Lordship,
antecedent.
So far
Lordship.
as contents of the FIR reflects the fact that the petitioner has made a physical relationship with
That's
the
correct.
victim on the pretext of marriage, which amounts to rape. That is why, Lordship, at this stage, I'm insisting on calling for
It's
the
a
case diary along with the statement of the victim. Let us call for the case diary, Lordship.
It is
anticipated bail,
totally
there is-
consent, fully consent, Your Honor. This mentioned. This informant has lost the affair.
It's an
It
admitted
means-
fact, but
yes.
on the pretext of marriage, physical relationship has been established, which amounts to rape.
She was a widow or
No,
She's a lady, she's a girl of aged about 19 years. So far as the FIR is concerned.
I may also be a lot.
So let us call for the case diary at this stage, along with the statement of victim.
But this, it's a fit case, Lordship. It's a interim protection for me.
CD will read and Lordship, let us decide.
administrator that they can call the petitioner and SH part petitioner be paid. This is an application. Submitted by Mr. From the simple reading of plain reading of the FIR itself, it reveals that it was the both the parties were married, and if any relationship was there in between them, was purely consensual and consensual. More so, the two cases registered under section 87 of the BNS, but there is no ingredients at all to affect section 87 of BNS, as there is no question of abducting or kidnapping of the victim of the However, the petitioner is still ready and willing to extend his cooperation in the further investigation of this case if he is granted with some interpretation. Next, MS Bora, the learned additional PP raised objection and submitted that even if there was a physical relationship between the parties, it was under the misconception of fact and with the assurance of marriage only. The accused had physical relationship with the victim, which amounts to rape. Hence, the CD will be required to know the actual fact of this. Considering this submission made by another or aspects of the case, this court is of opinion that interim protection may be provided in the present petition so that he can active and cooperate in the investigation. Okay, will be under interim protection.
Yes, Lordship.
Appear before the IO within 7 days and cooperate in the investigation. Yes.
14th of May, Lordship.
14th?
Yes.
Deeply obliged, Lordship.
Yes, we have received this scan copy.
Scan copy was called for, that is received, Lordship. The matter has been surseated and charge has been framed. Thereafter, Lordship, 3 prosecution witnesses has been examined, seizure witnesses, and the relevant witness, that is the informant and other police officials, are yet to be examined, Lordship. It's a commercial
The witnesses
quantity.
all are seizure witnesses.
Yes,
Yes,
Lordship. So it's a commercial quantity and the embargo of section 37 will come into play, and Lordship kindly consider the gravity of the offense as well as.
Your Lordship may kindly peruse page number 47, annexure 7, Your Lordship. One of the co-accused in this case, Your Lordship, already granted bail by the courted bench of this honorable court, Your Lordship.
The parity cannot be a ground, Lordship.
But I have shown my bona fide reason, Your Lordship. Your Lordship may kindly peruse page 5 of my petition, Your Lordship, paragraph number 6, Your Lordship, 5 and 6, paragraph number 7. I have stated the reason why I should be given the protection of the regular bail, Your Lordship. On earlier occasion, Your Lordship, under the direction of this honorable court, I have surrendered before the trial court, and there is no intention to abscond, Your Lordship. And I have fully cooperated with the process of the trial court, Your Lordship. And so far the seizure is concerned, Your Lordship, nothing has been seized from my physical possession.
Is this recovered from the premises of the petition?
Not premises, Your Lordship. It is a
Compound.
vehicle. It's a vehicle that do
That
not
is
belong to
inside
me, Your
his
Lordship.
compound.
That do not belong to me, Your Lordship.
That is inside the compound.
It is nothing is there in the charge sheet, Your Lordship, that this vehicle belongs to me.
I'm vehemently objecting his petition. It is the discretion of right of the power of the court.
Because one
Guarantee cannot be
accused
ground
already
for
been granted bail,
Granting bail.
maybe on
That will
maybe on
expect the court
different
is filing
grounds.
Lot of judgments. There's a lot of judgments of the export. It cannot be a ground for granting bail.
And there's every chance that I may be acquitted in this case. So why should I be behind the bar for unnecessarily, Your Lordship? Because 3 seizure witnesses, nothing has been revealed against me. There's nothing incriminating against me, Your Lordship.
Relevant witnesses are yet to be examined. But to kindly consider
Seizure
the gravity
witnesses
of the
can-
offense.
Seizure witnesses are independent witnesses. If they says nothing against me, where is the question of convicting me, Your Lordship? So I pray that I may be given the.
I'm objecting, Lordship. Parity cannot be a ground.
I'm not asking on
granting
parity,
bail.
Your Lordship, but it's a question of principle of natural justice and violation of Article 14 of the Constitution, Your Lordship. Because one accused already released, maybe on technical ground. But if your Lordship may kindly see the role and acquisition of both the accusers, same, Your Lordship. And if your Lordship may kindly see paragraph page 47 of the case.
Yes, some people. Where is your earlier bail order?
Earlier bail order at page number 42, Your Lordship. Annexure 6.
So since when you are in custody?
Since 19/4/2025, Your Lordship.
19/4/2025, you are in custody.
Yes, Your Lordship.
Mr. S. Legal Constitution. And also S.H. Bora Legal Petition. It's an application for section so and so. Scan copy of petition with paste. Mr. Decade runs responsible for the petitions. That the present petitioner is in custody since 1940. And one of the co-accused has already been granted bail by the coordinate bench of this court. And hence, considering the case of the present petitioner, it seems he may also be released on bail on the Mr. Decker further submitted that there was no recovery of contraband from his conscious position. And he also surrendered, and in person to the order of this court, he also surrendered before the court, before the police station. And hence there is no question of absconding if the accused person is released on bail. So rather, he will appear for the learned trial court below as and when the date is fixed for. Further submitted that 3 PWs has already been examined, 3 other witnesses have already been examined, and there is no increment, and the present petitioner was not incriminated by those other witnesses. So accordingly, he submitted that bail may be granted to the present petitioner, and he will abide by all terms and conditions imposed on him. Next one. MS Bora, the learned additional PP submitted in this report that severity cannot be the ground, sole ground for allowing the present petitioner on bail. Only only 3 other witnesses have examined by the prosecution, and the material witnesses, that is the informant and investigating officers, are yet to be examined by the prosecution. Further, it is a case of commercial quantity, and hence the rigor of section 37 will also follow present case and present case post. MS Bora further submitted that the recovery was, the recovery was from the conscious position of the accused petitioner, and it was recovered from a vehicle which was parked inside the premises of the accused petitioner. There are sufficient incriminating materials against the present petitioner and post petitioner and collected of the petitioner, and hence there cannot be any reason to believe that the accused is innocent or will not commit similar kind of offense as required under section 7 of the MS Bora accordingly raised payment objection and submitted that it is not at all fit case to grant bail to the present petition. Okay, I have recorded your submission. I'll pass the order after perusal of the case.
Lordship, as
Lordship,
regarding
kindly-
the ground of parity, to that extent, I'd like to submit some Supreme Court judgment.
Lordship, may kindly take into consideration paragraph number 7 and 8 of my petition. Lordship.
Yes, he has surrendered everything.
Yes, your Lordship. Obliged.
Okay.
Hey, please, your Lordship, 483 for regular bail.
Lordship,
Let
here
you was called for.
that we have not received, Lordship.
Lordship. Petitioner was arrested on 24/2/2026, Lordship. Lordship, today, Lordship, 61 days. We have fair page, Lordship. Lordship, page 9.
Lordship, it's a case of murder, Lordship. CD is required.
The fact is that though the accused petitioner have friendly relation with the deceased, Lordship.
and they used to work together. But on the day of the incident, the deceased went to Guwahati for work, and after returning home from Guwahati, he fell ill.
Maybe a fact may be there, but
Actually,
it's a case of
actually,
murder.
Yes.
Minimum perusal of the case diary will be required. So we'll try to accommodate which is short date. I don't know,
Mukalmoa PS, Lordship.
Mukalmoa.
Yes.
Mukalmoa, if it is Mukalmoa, then
On 8th. 11.
we'll do 11.
Along with the
CPO.
postmortem report, Lordship.
Pardon?
Along with the postmortem report,
Yes,
CD
along with the PM.
of that.
May I please, your Lordship? My lord, here in this case, Lordship, although the case is registered by the trial court as a POCSO case, in fact, Lordship, the FIR has been registered under section 87 for kidnapping. Charge sheet is submitted under section 87. Now the trial court, after going some record, finds that in 164 statement, 161 statement, the police has recorded that there was some relation between physical relation with the victim. But in 164 statement, Lordship, I have seen that she has denied that she has saying that there was no physical relation, and both the petitioner and the victim, Lordship, were resided separately. They were allowed. If you, Lordship, kindly go through the 164
No, we
statement.
need the girl.
But
What is the report?
my lord, in fact, Lordship, no case has been registered till date, Lordship, under POCSO. If you, Lordship, kindly come to page, just one page.
No case means what? It is charge sheeted, isn't it?
My lord, in fact, Lordship, notice may not.
What are you saying?
Lordship,
Noti-
kindly come to
Case
page
is a charge
33.
sheeted case. After considering all aspects of the case, the court framed charge under this POCSO Act, and now what?
Yes.
Hauraghat Road, and while asking us to stop, as such, he stopped the vehicle, and around 3-4 persons got down from the car and searched us. And after finding the rupees 10 lakhs back, took him along with the money in the car, and amongst them one person took the bike and fled away. Thereafter, through my friends, his Sagar cutlery in his bike, through search enquiry was done, but no trace of them was found. It is my doubt that this all was pre-planned by Sukru Singh Terang. My lordship may kindly say, and when the fact was that 1 lakh I borrowed from him. That is a fact. 1 lakh he gave me on interest. This person, the informant, I borrowed 1 lakh during the treatment of my mother, and I borrowed from him, and that was also in interest. Actually, I have paid some amount, but the interest accumulated. Thereafter, my lordship, as per my client, he called him to Dokmoka market. They went together, and thereafter they left their own places. Thereafter, this FIR was filed. My lordship may kindly peruse the genuineness. A person takes 10 lakhs rupees, calls at around 2:30 p.m. on the same day. He gathers 10 lakhs rupees on the same day. Calls him at 2:30 p.m. on the same day, meets him at Dokmoka market, handed him over the 10 lakh money. On the route itself, the incident took place. Actually, the fact is that it is a fact that 1 lakh he has given me, and I could not repay all along with the interest. But with regard to the facts of this story, my lordship, it is completely fabricated. And my lordship, the petitioner, he is a resident of that place. He has no flight risks, my lordship. And my lordship, he is willing to cooperate with the investigation and will face the trial, my lordship. But he is innocent, and moreover, he is not in that stage to give anyone a government job because he himself is searching for a job, my lordship. My lordship, the case diary will be.
My lord, case they received, my lord, from the allegation in the FIR on the pretext of providing a job in the forest department. And thereafter, my lord, on that particular day, my lord, victimized, my lord, that person, that is informant. My lord, ultimately, my lord, he my lord, handed over that 10 lakhs rupees, my lord, on that day. And thereafter, from the investigation, my lord, that on that day he asked him to come with him along in his bike, my lord. Thereafter, one of the friend of the informant is also there with him. He also, my lord, at that point of time, in his bike, my lord, moved, my lord, along with the, my lord, victim and one Sukru Singh Terang, who initially, my lord, took an amount of rupees 10 lakh. Thereafter, my lord, while both the persons, my lord, about to reach, my lord, that particular place, Hauraghat, my lord, near the house of the, my lord, that accused person, Sukur Singh Terang, then one alto Ketan is already there. They are all associate of the, my lord, accused persons in a pre-planned manner. Thereafter, they looted the amount. And after looting the amount, the vehicle of the bike, my lord, which was, my lord, at that point of time, my lord, ridden by the, my lord, accused Sukur Singh Terang, that was also taken away by one of the accused. My lord. Suppose if, my lord, their intention is not to loot that amount of money, then why one of the accused person, my lord, after they, my lord, taken away, not only taken away the money, my lord, they took along with them Sukur Singh Terang also. And thereafter, one of the accused from the Alto Ketan also take away the bike of Sukur Singh Terang. Later on, during investigation, police has, my lord, seized the bike from the residence of the present accused persons, my lord. My lord, brother of the accused Sukur Singh Terang, he has handed over my lord, bike to the to police, my lord. And thereafter, during investigation, police has also recovered 1 lakh from Sukur Singh Terang from his house on being raided by him. And regarding Omar Crow, my lord, initially in his statement, Sukur Singh Terang stated that Omar Crow is also, my lord, one of the prime associates. Thereafter, my lord, police also collected his mobile phone and mobile number of the present Sukur Singh Terang. And during CDR analysis on that particular day, total, my lord, his number লগত প্রায় 9 বার মান ফোন যোগে আলোচনা কৰা দেখা যায়. And he also in his statement named the present Amar Crow that he is also one of the associate of Sukur Singh Terang. And thereafter, police also verified the CDR. And during CDR also, my lord, it comes to light that total 9 times on the day of the incident, he contacted the accused person, Sukur Singh Terang.
So,
So in a pre-planned manner,
1 lakh at this time.
1 lakh recovered from Sukur Singh Terang. He was arrested.
And this was the 1 lakh, my lordship, not the 10 lakhs, my lordship.
In a pre-planned manner, my lord, they all conspired thereafter. After getting that amount of rupees 10 lakh, they all looted the amount. Thereafter, my lord, they also taken away my lord, one of the accused, Sukur Singh Terang, along with them.
How this Omar Crow was also, actually, he came in the bike. No, sorry, car.
Omar Crow is also one of the, he was there in the Alto Ketan. He thereafter looted Sukur Singh Terang and the, my lord,
Alto Ketan,
this bike is the owner of the bike is Sukur Singh Terang. Because while after handing over the money of rupees 10 lakh, the victimized person, my lord,
No, with Sukur Singh Terang, who was on the bike, the informant.
no, Sukur Singh Terang is not the informant, is the, my lord, victim, my lord.
No, yes, yes, Said Kusumotari or what?
Yes. Your lordship may kindly peruse one of the statement of his friend
In
who
his
was.
bike means Sukur Terang's bike, if he was taken.
Yes, Sukur Singh Terang's, he also, my lord, he was thereafter Sukur Singh Terang left him along with his bike. And thereafter, while they reached that, my lord,
That the incident had happened.
my lord, they all, his, my lord,
Now,
associate.
Omar Crow was one of the
associate, they were already there in the Alto Ketan.
occupant of the.
Thereafter, he along with other associates, my lord, looted the amount of money from
No, my
Sukur
lordship,
Singh
the
Terang.
FIR states the Omar Crow that bikeখন চলাইছিল that as per FIR. As per the FIR, my lordship. As per the FIR, the bike was ridden by Omar Crow.
No, not Amar Crow, my lord, Sukur Singh Terang.
Sukur Singh.
Sukur Singh Terang, not Amar Crow, my lord.
My lordship, my lordship. Sukur Singh Terang. My lordship, my submission is that, my lordship, I myself is not able to get any job. And my position is not that I could take this 10 lakhs, my lordship. But it is a fact, this victim, my lordship, the informant, is a rich person from whom actually the village people used to take credit money in interest system. So I have taken 1 lakh during the time of my mother's treatment, for which I have paid some money. Some are left with interest, it has accumulated. I am no way involved with this. And moreover, my
money
lordship,
is recovered from Sukur Singh.
Sukur Singh, my
From Sukur Singh, 1 lakh recovered, my lord.
My
Your
lordship,
lordship.
I am local resident. I will appear, I will face the trial, and my lordship, I will cooperate with the investigation with any stringent condition on any appearance every fortnight also, my lordship.
Now, police is searching Amar Crow, my lord. The FIR is registered on 21/12/25. 25, my lord. Since then, Only two statement, one Sagar Kaklari, the friend of the informant, and thereafter I have also flag marked the statement of Sukur Singh Terang.
This Sagar Kaklari was along with that informant.
Yes, along with the informant at that point of time.
So it is Sukur Singh Terang who specifically incriminate this
Yes,
person.
yes.
Submit. He is incriminating you also.
My lordship,
That
my
the vehicle you were there inside the vehicle.
lordship.
Amar Bro.
My lordship, my submission is that I will cooperate with the investigation, my lordship, and I'll face the trial with any stringent condition of every fortnight also, if or any conditions, stringent conditions. Because my lordship, since December, this person out of fear of arrest is turning hand his family, everything, my lordship. He is also a very day-to-day earning person. Because of my lordship, may kindly consider his
So why you indulge yourself in such a crime?
My
and
lord-
all that?
my lordship, with any stringent conditions, my lordship. I will cooperate with the any direction, my lordship, with the investigation, and my lordship will face the trial without default.
RMS SG Board particular consultation. It's not Swens. CD receives Swens. It is submitted by MS Board that the present accused petitioner is innocent that he is no way connected in the arrest. The FIR is launched only on suspicion that the person who came in a K10 Alto car might have been involved in the arrest. However, it is a fact that he took rupees 1 lakh from Sukur Singh Theatre on as a loan, and as a loan due to illness of her mother, his mother. And during the investigation, the mother, that apart, he is no way connected in the LS office. However, he is ready and willing to extend his cooperation in the further investigation of this case if he is provided with the privilege of being arrested. MS Board further submitted that the present accused petitioner is a very poor person and earns his livelihood by doing some labor work, and hence he is not in a position to provide any job to any person at least in the area. Next, Mr. Bott put it on a petition 50 days on which and submitted that a rupees 1 lakh had already been recovered from the FIR accused Sukur Singh Terang, but from the statement of the co-accused and the other materials available in the case diary, it is said that present accused petitioner is also involved in the alleged crime, wherein he was one of the occupant of the K10 Alto car, whereby the offense was committed. Accordingly, Mr. Water who raised objection and submitted that will not be a fit to extend the privilege of pre-arrest bail to the present petitioner. Next, hearing this submission made by the counsel for both sides, considering all aspects of the case, this court is of opinion that one chance may be given to the present petitioner to extend his cooperation in the further investigation of this case. And accordingly, and it is to extend the privilege of pre-arrest bail to the present petitioner with certain conditions, only to cooperate with the investigation. According to, okay, we are granted with pre-arrest.
Obliged, my lordship, highly obliged.
Dispose of milk. This one. Yes.
Yeah, please. Sir. The anticipatory bail application, Your Lordship.
Hello, in this case, short sheet submitted. Ma'am. Yes, sir.
Are you on interim there?
I am in it.
Okay, then we'll extend your interim.
Yes.
Yes. Card MS AMC, Dilan counsel for the.
Yes, ma'am.
Oh, sorry, Assam, Dilan counsel for the petitioner, also had Mr. P. Waterford, Dilan petition PP appearing on behalf of. And the case record was fixed. Case was fixed for case diary, but it is submitted by Mr. Waterford. That case has already been charged. So yes, CS number. What is it?
CS number 30/26, dated 21 to 26.
We are extending your interim after
Yes.
15 days. FF.
Okay.
Okay.
I please, Your Lordship.
Oh. 22, my lord, case diary not received.
Not received yet.
I have already appeared, my lord. Notice has been 35(3) notice has been issued. So thereafter, I have appeared also after getting this interim order, my lord. So I have given my statement out before the public.
You are for the informant.
PD not yet received. My lord. On
He is also want to submit something, I think. So let the CDB come.
Yes.
Heard Mr. PM and also for the petition. Also heard Mr. P. Waterford and and your MS?
AN
MS AN?
Hussein.
AN Hussein. Then I consider appearing on the respondent number. City not received, should remind. Yes, when it can be.
On 13th of May.
1 3 so and so. Interim be continued in next set. If you have already appeared, it will come reveal from this.
My lord, much obliged.
23.
Yeah.
May I please, Your Lordship, my lord?
We have not received the objection. Really.
Yes, my lord, after some time it matter may kindly be.
But you have just now, my court master has informed that you have filed your objection yesterday only. So if it is on yesterday, then it should come otherwise.
No, my lord, today I filed.
Oh,
Morning.
Today, morning?
Yes, my lord.
Oh.
My lord, as per my information, that has
Herein
been
also,
said.
Your Lordship, I have also filed one additional affidavit, Your Lordship. I think that is. Yes, and today, just now, Your Lordship, I have received the copy of the objection. So can it be, Your Lordship, it one, the CDS, na?
CDS.
Then 128, Your Lordship, if it is possible.
You have received the case diary.
Case diary received.
One thing heard Mr. A.M. Khan, the landed counsel for the petitioner, and also heard Mr. P. Waterford, the landed petitioner, appearing on behalf of said respondent, and Mr. You are Mr.
MS Taluka.
M. Islam, appearing on behalf of the informant respondent number 2. It is submitted by Mr. Islam that he has already filed the written objection against the bail petition, but on inquiry, it is seen that the office has, it is not, but on inquiry, it is not reflected in this website, and hence the registry is hereby asked to take the written objection filed by the respondent number 2 of the complainant on the next date of list. CD received, retain the case diary till next date of listing. Yes, 28. 30. He's saying 28 with many matters are there. 3030.
Yes.
Interim. Interim be continued till next date. Hopefully, by that time we may receive your. It is not showing on the website also.
Lordship, due to some personal difficulty, engaged counsel Mr. Das won't be able to conduct the matter today. Can it be
You're taking it for time being, or you want an adjournment? Today?
adjournment, Lordship?
Scan copy you have received, na?
Yes, scan copy.
Mr. Dilanet counsel for the petitioner and submitted that due to some personal difficulty. The NPS counsel, Mr. Esther, is not in a position to argue the matter. However, the scan copy of the TCL has already been received. List the matter 30.
I'm obliged, Lord.
26.
26 case diary not received. Petitioner is in interim.
You are in dream.
Yes, Lord.
Seed not received, is remanded. Yes, Potaku, when it can be?
On my lord, 18th of May.
18th May, interim be continued till next day.
18.
27.
May I please, your Lordship? Pursuant to this honorable court's previous order, I have appeared before the IO. I have given my statement and I have joined the
Just a second.
investigation.
We have received the case diary.
No, my lord, case diary not received.
Not received.
Not received.
No, interview.
You were on interim.
Sure.
You have submitted that as per the order of the interim order. You have already appeared.
Yes, Lord.
But we have not
Received
seen
the-
your this case diary is not
Yes.
available. We're extending your interim. Okay.
Yes.
City not received. Issue reminder.
On
Yes.
15th of May.
15th of May. Interim be extended till next day. You will be interim is extended after.
Much obliged.
Yes.
I'm on interim.
City received here.
Case diary received, my lord.
Here,
You have already appeared.
my lord, I have appeared. Statement was recorded, my lord. Actually, it's purely a case of accident, my lord, where 105 culpable homicide notable.
Yes, on that day you have submitted.
Yes, my.
Case is registered
Yeah.
105.
105, yes, my lord, and 1061 also, my. So both cannot be there, my lord. 105 does not attract, my lord. It's purely a case of accident. my lord.
Yes, Potaku.
He appeared, my lord. Other witnesses implicated him. He was the driver of the
Yeah.
tractor, my lord. He, my lord, while in a rash and negligent manner, he was at that point of time driving. And after he, my lord, hit the bike, my lord, both the, my lord, riders of the bike thrown away. Thereafter, on the opposite side, one truck, my lord, hit them. And thereafter, my lord, one of them died.
He is the driver of the tractor.
He is the driver of the tractor. My lord, he was driving in
But
a.
obviously, it is a case of negligent or
Yes.
the ration negligent.
Yes. He appeared, my
May
lord.
not attract 105, I think.
Yes.
Anyway, his statement is already recorded.
Yes. He appeared, statement recorded.
Heard Mr. H. Ali, learned repetition. And also heard Mr. P. Waterford, learned additional PPA being This is an application that they can show into in connection with Swain's CD received. Mr. Ali, the learned counsel, the petitioner submitted that for obtaining the order of interim period is bill dated 18/3/2026. He already appeared before the IO, cooperated in investigation, and his statement is also recorded by the. He further submitted that from the plain reading of the FIR and the other ingredients, it is not a case under that case there is no ingredients to attract section 105 PNS, and it may be a case of rash and negligent driving at best. However, he is still ready and willing to extend his further cooperation as and when it would be required. Next one, Mr. Waterford, done an additional PP submitted in this record that the accused appeared before the IO and cooperated in the investigation. And from the materials in the case diary, it is seen that it is a case of accident wherein the petitioner had drove the tractor in a very rash and negligent manner. During the submission made by common materials available in the case diary and other aspects of the case, this court is of opinion that custodial interrogation may not be required in the present case, and accordingly, I find it difficult to extend the privilege of pre-arrest representation. And hence, the order of interim pre-arrest bill dated 18/3/2026 is hereby made absolutely same terms and conditions.
Public.
My lord, 33 and 34 case diary not received.
May I please your lordship? Actually, the third time the learned friend is not able to produce the case diary, my lordship. The police are coming to my home now and then, my lordship. It's 2 months left, past my lordship. 3 times, my lordship, call for the case diary. The investigation officer not providing the case diary, my lordship. So I might be getting arrested at any point in time, my lordship. So, my lordship, may I just argue the case on merits, my lordship, because other co-accused are pre-arrest granted bail. But the offense are the same, my lordship. They are as per the FIR, my lordship. So let's kindly read
You may
FIR.
argue, but there is
Well,
nothing
without
to
having
be-
the CD, how
how
can he
he
argue?
will
on
argue?
Well, actually, this
merit?
third time my learned friend is not able to produce the case diary, my lordship.
Third time?
Yes, my lordship, it's third time, my lordship.
How third time?
This is third time listed, my lord. Earlier 2 times CD was called.
Third time was.
Now see, on 19/3/2026, an order was passed that at your request, the matter was
That's the
listed.
first matter. Then second, third, fourth is
Just
there, my
the
lord.
second.
CD was.
And then on 25/3, the matter was there listed, wherein we call for the case diary.
Yes.
And 8/4, my lord, before the day of the election, my lord, on 8/4.
It was received on 7/4 because the 8/4 probability of receiving case diary was less. In fact, it ought not to be having listed on 7/4 or 8/4 because these are the dates.
Yes.
Most probably the entire police machinery was busy with the election duties. So let us find, yes,
Lordship,
from where it
may
has
I
to
just
come.
pray from
Just a
Golfara, my
second,
lordship.
what?
From Golfara, Sunari police. Lordship, may I just pray it Monday, my lordship. May the list come in some supplementary
again
list, my
we'll
lordship.
list
Otherwise,
another
my
day.
lordship, this application will be
If it is
infructuous, my
fixed
lord.
on Monday, then we'll again list it for another day.
My lord,
Monday, not at all
this is a
possible.
lot of
Today
time
is
taken.
Friday, Saturday,
My lord.
Sunday is closed.
Lordship, kindly understand my difficulty, my
No. I'm not understanding your difficulty. I'm saying that even if it is fixed on Monday, it won't come. That's what.
my lord.
It won't come at any
Understand.
cost. It won't come because tomorrow is Saturday, is a holiday. Sunday is also closed. No order will be there.
May I humbly pray in Tuesday, my lordship.
Lordship may fix it on first week of May, 7th or 5th of May, anything.
It's very late, my lordship.
It is AB, isn't it?
AB, my lord.
AB, my
Is
lordship.
there? What
But
is
police
this?
are coming in my home
You are
now.
not behind the bar. It is AB only.
My lord.
Already rejected by the trial court, my lord.
Already rejected. No, maybe 7 may be a bit
Yes.
lengthy. I think try to find it.
Can it be?
Because first is a holiday, I think. Na? Second to Navinara. Third is a Sunday.
Fourth, my lord.
Fourth and 5. 424 at least fourth.
Fourth of
Deep levelized, my lord.
You should remember.
34 the same matter.
33 and 34.
34, yes, my lord.
4th of May. You should remember. One more down. Delta was up. Oh.
Deeply obliged.
May I please? But in this case, report was called for, but then my lord, there was no case registered at that time. And
Now I have received the report, my lord. One Mukalmua PS case number 20/26 under section 126(2), 1182 and 1091, the BNS registered against.
Already been raised.
Yes.
So have you appeared?
yes, I appeared, my lord. I appeared there, my lord.
Appeared.
Yes.
What is the Mukalmoa PS case number?
Mukalmua PS case number 20/26
Under
under section 126(2), 1182 and 1091 of the BNS.
Parties to J Prime and also parties to keyboard and additionally status. Report is received from Mukalmoa PS, wherein it is stated that a case has already been raised against the present petitioner under Mukalmoa PS case number 20 of 2026 under section 126(2), 1182, 1091 PLS. Next paragraph is submitted by Mr. Payne that after obtaining the order of interim protection, the petitioner had already appeared before the IR and cooperated in the jurisdiction.
I appeared before Adabari outpost, my lord. Because,
Adabari?
yeah, Adabari outpost.
Oh, but it is
Mukalmua police station.
The Mukalmua police, Adabari police outpost tells under the Mukalmua police station.
Submitted
So it is
that
called.
little just submitted that he had already appeared before the police officer of Adabari outpost under Mukalmua PS and cooperated in the jurisdiction. In view of this, let the case diary be called for. And matter may
On 19th of May.
19th of May, so as an interim be continued till next day.
Always.
Right, your lordship.
Yes.
This is page 11, cases that might have the petitioner, he is a matter of senior, might have customer service assistant at Central Bank. The allegation is that might have some withdrawal. About some withdrawal matter. Here the case is might have the manager, your lordship can see the no FIR is page 11, my lord, page 11. And he was put under suspension, still he is under suspension. He has no access to the department of bank also, my lord. So for that purpose, my lord, it is everything on the record, my lord. Last time also your lord seen, but your lordship was not inclined to give interim order, my lord. It came before last time earlier, my lord. So my only prayer is that, my lord, only at this stage, my lord, whether custody interaction is required or not, my lord, on the faith of the records, my lord. This is my case, my lord. And paragraph 5, I have details I have given, my lord, paragraph 5. Yeah. Page 11 is the FIR and my
The Central Bank.
Central
Yes,
Bank.
Central Bank.
Central Bank. Senior customer service assistant. And just I'm reading my one paragraph 4. Just have a look at paragraph 4, my page 4. Your lordship. Page 4, paragraph 4, my.
Yes.
Yes, innocent, false. During his service, the petitioner noticed that the bank manager has given mortgage loan to various persons of that locality upon harsh plot of lands, and after noticing this, the petitioner protested against it. And regarding this, an enmity started with the branch manager. The petitioner was often deputed by the branch manager to conduct field inquiries outside the branch in connection with the bank work. During such time, his computer system remained logged in at the branch premises. It is reasonably apprehended that taking advantage of the said circumstances, certain transactions were carried out through the petitioner's login credentials without the knowledge or consent.
Moreover, some of the disputed transactions relate to accounts which are being handled by the other employees of the bank, which prima facie show that the petitioner has been falsely integrated. The informant, without hearing the accused petitioner, suspended him and only to harass the petitioner, hence the employer so and so forth. My only question might be suspended. Till today, he's in suspension, no access. Everything is there on record. Custody are not required. This is my humble submission by the Lord.
But from the my lord case diary, it reveals that my lord, individual customers has lost complaint against the present petitioner, that he has illegally withdrawn money from their account, my lord, and thereafter, my lord, during investigation, bank has also, my lord, investigated the matter on the basis of the there are my lord, complaints of the customers, that those complaints are available in the CD, my lord, and thereafter, during inquiry, my lord, from total 5 accounts of the customer, total amount of rupees 1,29,000. He has withdrawn, and thereafter, my lord, on further verification, my lord, it reveals that a total amount of rupees 4,81,578 he has, my lord, illegally withdrawn from the customer's account, and thereafter, my lord, he has also refunded an amount of rupees 1,21,500.
Yes.
And till now, my lord, he has not. Total amount of misappropriated amount is 3,61,078 mil. So he has in fact admitted after, my lord, during inquiry, my lord, not only on the after getting the complaint from the customers, inquiry was conducted. Thereafter, on further, my lord, inquiry from some other customers also, it revealed that he has withdrawn amount in this manner. So these are serious offenses, my lord, from the customer's account, my lord, which are in the bank, my lord. He has withdrawn money, and thereafter, my lord, during investigation also, my lord, total, that is also in fact from the FIR itself stated that contents of the FIR is supported by the state from the materials available in the CD, my lord.
That fact, my lord. It is on the
Total
record, my lord, one thing, my lord.
51.
Already he, or knowing he paid also something. Even if it is found that he is liable, my lord, you will pay, my lord. That is also my instruction, my lord, if he is found. That is everything on record, my lord. I am not saying, my lord, everything. And if your lordship, my lord, is a custodian, required. Government employee, my lord, he is employee with the bank, my lord. Suspension, not accepted.
Individual complaint of the customers also available.
Mr. Senior assistant by
S. Nazneen.
S. Nazneen.
Nazneen.
S. Nazneen, demanded for the petition. Also heard, so we want to put it on attention. This is an application, section present whose petition is no be connected in the other. He further submitted, he was reporting as a customer service assistant in the Central Bank of India at Krishnai Valpara branch. During that period, there was some enmity with the regional manager of the said bank. It was to be further submitted that during that period, that many complaints were received from certain saving account. Various person on with various during that period, the branch manager used to used to give a loan on land mortgage to them without mortgage loan to various customers upon first plot of land, and when the present petitioner raised objection, there was dispute between the branch manager and the present petitioner, and for which with some false and unfounded allegation, the FIR has been instituted against him. It was further without any hearing, without giving any chance of hearing, he was put under suspension. as the accused petitioner is under suspension, he has no access to the any document of the bank or other officials, access to the document of the bank officials or the bank, and he is ready and willing to extend his cooperation in the further investigation of this case if he is granted with some interpretation, some protection. Mr. Bond, that additional PP is obliged submitted that from the metals available in the case that it is seen that the present accused petitioner we used to withdraw money from the various accounts of the customer without any intimation to them. Initially, it was found that rupees 129,000 was withdrawn from 5 numbers of accounts, but during investigation, it had come to knowledge that he had withdrawn around 4,81,578 from various accounts of the customers. However, during the pendency of this case, he already returned on 1,29,000 customers, and the remaining portion is still to be paid by. The remaining portion is still to be paid by. It is a further submitted that it is a case of misappropriation of the public money, and hence there is need of custodial interrogation will be custodial interrogation will be required to unearth some more facts of this case. In that regard, Mr. Chaudhary, the learned senior counsel, submitted that he, though there was allegation against some some allegations was brought against him, he had already paid some amount of money to the customers, and he is still ready to pay if there is any other misappropriation of the money or during his tenure. However, at present, he is under suspension and has no access to the any bank documents or relevant documents. Those customers statement is there, no?
Customers, my lord, complaint is there, my lord. Complaint they have filed, my lord. I will point. Yes. Complaint of the customers, my lord.
During the submission made by them, I have also paid the case diary, and it is seen that there are some complaints made by some customers regarding misappropriation of some of their accounts. During the pendency of this case, it is seen that 129,000 has already been refunded by the present petition, and with a further assurance that he will refund the entire amount, if any, refund the remaining amount of the customers, if any. Considering this aspect of the case, and also considering the fact that basically the case is based on some documentary evidence, wherein present petitioner had no access as he put under suspension. And this when it is put under suspension. So in view of the above and considering all responsibilities, this court is of opinion that one chance may be given to the present petitioner who appeared before the IO and to extend his cooperation in the further investigation of this case, and also to produce any relevant documents, any relevant documents, if any, before the IO to for proper investigation in this case. Accordingly, the CTB returned. No. Accordingly, the present petitioner is provided with some interim protection till receipt of the act. We are protected, giving one chance to appear before the IO and produce all the relevant documents, if any. And in the meantime, I have already recorded that you have refunded some money.
Yes.
And if the rest portion is, you're still ready to refund the money, you can also refund it.
If it is forwarded, I am
If it is
certainly
also-
married. Obliged to us.
Updated case
Will it
diary
appear
will-
within,
Pardon?
within
Within 7 days.
7 days? Obliged to us.
7 days only.
On 24th of May, madam,
24.
I will return the case diary first.
Obliged.
It will be returned by calling for.
So it is pending, my lord.
Yes, it is
Pe-
pending.
pending.
Let us see here. Oh, कोई टाइमिंग कोई नहीं. My lord,
what
kindly,
37?
this matter may kindly pass over for the time being, madam.
You are looking.
She may fix at 2.
No, 37, my lord.
37 maybe fixed at 2.
Yes, okay.
May I
38
please, Your
and
Lordship?
39 row we fixed at 2, we have
Lordship,
already
hi.
here.
I was busy in another quarter, so that's why I have mentioned.
So anyway, we
if
fixed
you-
it at 2, if you are free, then we can hear it. No.
Yes, Lord.
Okay.
Now I'm.
Okay, no issue.
Even 38, 39.
38.
Case diary received, madam.
Lordship, here the allegation is that Lordship, the one
38 and 39 both out of same FIR?
say out of same affair, Lordship. Allegation is that Lordship, one lady has been beaten up by some people in a marketplace, suspecting to be a child lifter, Lordship. Alia Lordship has dealt with one case also in this matter, Lordship. Yeah, Lordship, my limited submission would be, Lordship, the sections registered in this case, Lordship, all are available except 118, Lordship. Grievous hurt with, Lordship, dangerous weapon, Lordship. If Lordship, in my submission, Lordship, section 1182 will not be attracted because if Lordship, there is no use of the weapons, Lordship, as section 101, 118 says, Lordship. So, Lordship, CD will reveal, Lordship, but as per my Lordship submission, Lordship, this section will not apply, Lordship, and section 117 will applicable, Lordship. Then, Lordship, section 117 is available, Lordship. This is my limited submission, Lordship. The affair is at page, Lordship, 12, Lordship.
You are named in the FIR?
No, Lordship, not named. Because the offense, LS offense occurred in a public place, Lordship, in a marketplace. Her victim's daughter has lost the affair, saying that he has seen a video in the Facebook that her mother has been beaten by public, suspecting that she is a child lifter, Lordship.
How many petitions are there in part 30?
Lordship, in item 38, two petitioner, Lordship, in 39, one petitioner,
One
Lordship. In fact, petitioner number 2 in item 38, Lordship, he is a Lordship, a medical professional, Lordship. He has a Lordship, medicine business, Lordship, medicine shop.
One old lady, my lord, those
That's-
accused persons in a group, my lord, brutally assaulted, my lord. Injury report also received, my lord. some of the accused persons also arrested after getting the video footage, my lord. And my lord, thereafter, when the my lord, daughter of the my lord, that victim, my lord, through my lord, he came to know about the incident. Only those, my lord, that incident was viral in social media, and thereafter, my lord, she immediately informed lodged this FIR, my lord, and from the after verifying the video footage, police arrested some of the accused persons, and now the police is in charge of the present accused persons, my lord. They are absconding, my lord. Brutally assaulted, my lord. Injury report also received, and regarding it for attraction, my learned friend, this sharp weapon is not necessary, my lord. Dangerous weapon is sufficient for previous. Any comment? Type of weapon is not there, my lord. Type injury, my lord. Previously.
one 70 একটা previous card আছে। So 118 তো এসব no weapons. If lordship the weapons have been mentioned that which attract the section 118, then lordship it will be different case. But we cannot support such type of incident lordship, but in a public place it's happened lordship. I am not admitting that I have done that offense lordship.
Why are you apprehending? Police is searching for you.
Police is searching lordship. Probably lordship based on video appearance in our face lordship in the video, maybe lordship.
Oh, in a group of persons, my lord, maybe they can, my lord,
Many people gather
this
lordship.
woman assaulted, my lord. She is also suffering from some, my lord, mental problem also, my.
I cannot support lordship such assault lordship, but lordship my
And some of the persons who even identified the victim, my lord, they even told the accused person that he is a resident of that place.
my submission should be lordship if the instrument for shooting, stabbing, cutting, or lordship weapons which are to be used to be for which is likely to cause death. If these weapons are not present, lordship, my 118 will not attract lordship. Section 117 will attract lordship. Otherwise, that offense is lordship bailable lordship. So, lordship, our custodial interrogation is not required, lordship. We will cooperate, lordship. Lordship, where Lordship has considered in another matter, Lordship, connected matter, Lordship. Here also Lordship has considered, besides the Lordship length of detention, Lordship also Lordship has considered that the section 1182 will not, may not be applicable.
Find specific names, find it.
Yes, madam.
Specific names of these.
Specific names, my lord, now those statements of the accused, but because only basis of that video footage, my lord, those accused persons who were arrested identified. And last portion of the case diary, my lord, that my lord, now the police on the basis of that video footage, probably the accused persons are searched by the petitioner. In the vital portion of that, my lord, victimized person attacked by the accused persons, my lord.
So Mr. Abbas.
Lordship.
আর Mr. একে হতে পারে একা দুজন আছে।
That was a connected matter BA Lordship where 4 people were arrested, Lordship. That in that matter, Lordship, besides the considering the length of detention, Lordship, that 118 will applicable on
The length of
Lordship.
detention was there.
Yeah, 118, my lord, does not say anything about sharp weapon, dangerous weapon or means, my lord. And what type of weapon, my lord, dangerous weapon or means, my lord, that it is not specifically stated anywhere that it should be a sharp weapon.
But stated, Lordship, it that the instrument for shooting, stabbing, cutting, or any instrument which
And
is
those
likely
things
to
will
cause
come
death.
during the trial, my lord. This is AB, my lord, they are now absconding.
If our name also not
That is
reflected
taking
directly.
part of the petitioner. my lord.
Also the additional PPT. Submitted to extra positive petition. And they're not all connected with the alleged offense. However, it's the fact that one incident had happened wherein one old lady was beaten up by some person on suspicion of a child. But these petitioners were no way involved in the alleged offense. On the basis of some video footage, some of the persons already got arrested in this case, and the present petitions are not related to the said offense. If further submitted that the case is registered under section 1182 PNSL, which is the only non-bailable section of the case, from the it is seen that a same manner be affected against the present petitioner, as there is no mention of using of any dangerous weapon of shooting, stabbing, or fire, etc. Even if it is affected under section 117 to IPC, it is available offense, and the other offenses are all are not available offense, under which a case was registered. Mr. Abbas further submitted that if there is no use of any dangerous weapon or a sharp object, the case cannot be taken under 1182, and that apart the co-accused persons were already granted bail by this court, and considering the case of the present petitioners in the same footing, their bail may be considered. However, they are still ready and willing to extend their cooperation in the further investigation of this case if it is granted with, if they are granted with the privilege of yes. Next one, Mr. Lockwood, Mr. Watford, submitted in district that the daughter of the victim had lost the FIR after perusal of the CCTV footage and the viral video, wherein it was seen that a group of persons assaulted her mother with a suspicion of the child victim. Mr. Potter submitted that the medical report is available, case record, whereupon it is seen that the victim sustained previous injury on her person, including on the scalp of the head, as well as she also sustained fracture injuries on her right hand. He further submitted that a group of persons had brutally assaulted old lady, only on suspicion of a child victim, and hence the custodial interrogation of the present petitioner may be required for the purpose of investigation. Getting this submission with well and also paid the case died. It is the fact that the victim sustained previous injury, that is fracture injury, along with some lacerated injury on her scalp, but there is no mention about the types of weapons used in the medical report. Medical report to effect is a well settled that it is well settled that to effect a section 118 subsection 2. The description of weapon must be there, and it should be a dangerous offense weapon, including the weapon of including the sharp object, fire, corrosive things, etc. But in the medical report, there is no mention about it, and no mention about it, though the injury is reported to be fracture injury of the previous. Considering this aspect of the case, the other available materials in the case diary, it is seen that there is no specific allegation brought against the present petitioner, but the investigation is still under process, and during the investigation, some other facts might have come into the light. So, considering all these aspects of the case, including the medical report and other matters in the case diary, this court is of opinion that custodial interrogation may not be required for the purpose of investigation. However, the cooperation of the accused petitioners will be required during the investigation, and accordingly, they will abide by all terms and conditions to be imposed on them. Okay, you are granted with bearer's bail, appear before the IO, cooperate in the investigation.
Deeply obliged, Lordship.
And within 7 days, you appear before
Lordship.
and cooperate.
I will appear, Lordship. Deeply obliged, Lordship.
It may not be necessary. Read that. Itu dia. Itu sudah. Itu dia. Watch it. Dua apa? Boleh dua apa? Ini kalau boleh tadi. Kotakur.
Yes,
we one case we given date of 24/5. That is on item number 36.
36, yes.
24/5 is a Sunday.
Yes.
We make it 25/5.
Yes, ma'am. Yes, 25.
For addiction, I cannot file it.
May I please your lordship? Lordship, this on
You are
last
for the
occasion
record.
also they did not appear, my lordship. My lordship, here this revision is with regard to the concurrent findings, with regard to NI proceeding. The SEC was issued the proceeding started in 2015, my lordship. And now it is 2026 and the appeal was filed. My lordship, this revision was filed. My lordship may kindly be pleased to peruse only one ground, with only one ground at page number 6. Initially, the matter came up before your lordship. My lordship did not permit it for any stay, and thereafter they deposited some amount with an observation that they will give the complete amount within 6 months before this court. And now, my lordship, it's more than 10 years. My lordship may kindly pay 6, my lordship. For that now this is the ground, only one ground, my lordship. For that now his commercial building with 15 lesser land at Panigaon nearly covered by dark number, pata number dash, situated at dash under North Lakhimpur Revenue Circle is acquired by the Deputy Commissioner Lakhimpur for construction of new highway connecting from Bandordua to Nagaland. NSS, the petitioner prayed for compromise the matter and also prayed for some time to repay the said amount before this honorable court till he received the compensation amount against the acquired land or in any other ways. This is the ground file. He is observed. My lordship stay is granted, and today till date he has not paid anything. And last occasion also, my lordship, he has not appeared. Today also he has not appeared.
Last occasion, just
In the morning, they stated that they will seek some time, my lordship, on last occasion. And thereafter, my lordship, we were on an impression that time will be short by them. And my lordship, in between, they have also filed an application, another application before this honorable court on 8 June 2023, that the petitioner further prays before this honorable court that he will pay the entire remaining amount within a period of 6 months and prays to consider his prayer before this honorable court. So
it was
this,
filed
on 8 June 2023, after the interim was granted, no, here, this
Yeah.
honorable court. Initially, when the matter came up, my lordship, it came before your lordship only. My lordship has not granted any stay. Thereafter, they filed an application stating that they will deposit some amount. We then further granted that they will pay the remaining amount within 6 months. So the stay was granted. Then the matter was in this domain only. Then thereafter, on 8 June 2023, they again and filed an application before this court itself that they will pay the entire amount within a period of 6 months. And now my lordship is 2026. They have not paid, and only ground, my lordship, it cannot be a ground in a ground is that a land is there which is acquired by government. When that land, he will get the compensation, he will pay the amount. And this is the only sole ground filed in this revision petition, my lordship. I'm praying for a disposal in this matter because it is against concurrent findings. Amount was 4 lakhs, my lordship. And the initial, check was of 2015. And the Honorable CJM has passed the order, my judgment on in 2021, my lordship. Then it went for appeal. Appeal also, it was upheld to 4 lakhs. And against this revision, my lordship. And even, my lordship, I feel that there is also an order of this honorable court prior to last date that no more further adjournment will be sought by them. So many times adjournment, and I also consider, because my lordship, they always put in guarantee that they will deposit the amount, my lordship. Because it's 4 lakhs, my lordship, it's been more than, from, if I go by the check amount of 2015, it is 2026 now. And
It's not the observation of the court that no further adjournment. It is your submission. MSSG Purva
yes,
submitted there
No,
should
no.
not be any further.
Yes, because my lordship, they seek time. So I have also know, being a friend, my friends used to appear. So my lordship, on last occasion, they stated that they will seek only 1 day. So I wasn't impressed. I didn't come to court, and thereafter I came to know they didn't pay. And today also same. And if my lordship feels that since it's a revision petition and without the appearance disposal, my lordship is on that, then my lordship may be pleased to give one legal aid or anybody to represent the matter. If my lordship feels that without the appearance disposal might not be possible in that case. Because my lordship, only 4 lakhs and 2015 till 2026, and my lordship may see the ground. And moreover, his conduct.
Generally, in criminal appeal and all, if it is supposed admitted,
then it is
invalid. But it is a revision only.
Revision only, yes,
If
my
they are
lord.
not interested.
Yes, they may not interest.
Do you have any information from your client that whether they have paid anything?
No, only 1 lakh was deposited with our registry to get this stay order, and no more. I had today morning.
at these two occasion. And now, just a minute. On 17/2, Mr. B. Islam was appearing on 17/2.
Yes.
On
Yeah.
17/2, I'm just
Yes,
asking
yes, my
17.
lordship.
And then on 12/3.
Yes.
12/3.
Yes, my lordship. Actually,
Where
it's not
from
least.
your side, a prayer was
Yes.
for adjourn.
Yes.
But it's nowhere written as to whether the other side was present.
Yes, my lordship, they were.
Coming to 24/3 then.
Yes, my lord.
In 24/3, obviously they remained.
Actually, they were also sick because they actually the conducting council is my neighbor at my native place. So I also have every time I go, but sometimes my lordship I cannot go by all those because my lordship be pleased to peruse if the highlighted part. This is the affidavit filed before this court on 24/3, where they gave assurance before this honorable court. Only the highlighted part because they gave assurance before this honorable court that they will pay the amount within 6 months. So that is also more than sufficient, my lord, because they only gave assurance. And like the ground of appeal also, my lordship, in a NI matter.
It was basically an NI.
NI, my lordship, 2015 SEC and now 2026. And the check was of 3 lakhs. And the court ordered for 4 lakhs. And from 4 lakhs till 2026, the value has also till there. And I cannot go for execution because stay is there. Or my lordship if my lordship feels that if my lordship wants to dispose if my lordship, that would be more convenient because disposal this matter is
do one thing. And a person called respondents and it reports the record as submission made by school present additional remain at next two occasion and further witness Apurva also provided one affidavit sworn by the petitioner that he will pay the entire amount of entire remaining amount within a period of 6 months. Within a period of 6 months. But even after this, quality notice say that till that except rupees 1 lakh, no further payment is made by the petitioner, and they are also enjoying the order of stay. MS Purva accordingly submitted the matter will be disposed of in this common petition, considering the submission made by against counsel for petition and respondent, also for instance, one which is given to the respondent, and in default, the consequence order will be passed. Right? We're giving a short date, just for short date. 6th of May. 6th of May. We'll pass the order.
My lord. My lordship, can it be on 7th of May?
7th.
Obliged, my lordship.
So you are for the petitioner here.
I'm for the petition, Lordship. Learned counsel for the respondent number 1 is absent, Lordship, on 16/10, 21/1, 27/2, 2026, Lordship. They're absent, Lordship, so their name were reflected.
The state is also a party here, or what nature of case? Formal party.
Formal party, Lordship.
CR petition, my lord.
CR, Lordship. Actually, what happened, Lordship, criminal defamation was initiated on the basis of non-FIR, Lordship. FIR was faced, lost, Lordship, then police investigated and submitted report before the learned magistrate that section 500 is not non-cognizable, Lordship. Then on the basis of that report, Lordship, cognizance was taken, Lordship, which is not permissible. And we are only on law point, Lordship. Section 199 CRPC does not permit, Lordship. Defamation can be initiated only on the basis of private complaint
to be filed before the magistrate. Lordship. That is the case, very limited.
But as per you, this was initiated on the basis of the
Police FIR, Lordship.
not FIR, report of the police.
Report of police, yes, Lordship, subsequent, which is not permissible. That is very limited issue, Lordship. We are not on merit, Lordship, only merely on law point. Scan copy was called for last occasion. That is also received, as reflected in the progress, Lordship.
The name of the, my lord, that is the respondent number, one's counsel, also, my lord, shown in the cost display.
They are
Yes, yes, they are
They
there.
are absent on 3 occasions.
Otherwise, my lord, the contention made by the, my lord, that is in, my lord, para 3, my lord. Para 3, page 5, my lord. Where the order against whom, my lord, that is the selling, my lord.
And that is the only.
Yes. But still, this, not as because my lord, complaint case, my lord, and their name is shown, my lord, the landed counsel's name for the petitioner. Whether, my lord, it will be better to take the matter, or, my lord, better to give them one chance. Otherwise, my learned friend has submitted it in earlier in 3 occasions.
That is on record.
They are not.
That is on record.
In 2 occasions, they were.
Yes.
And one apex court judgment is also there, Lordship, in Subramaniam Swami's case, Lordship, that police cannot, Lordship.
No, police to cannot.
Lordship.
Here also, police is not registering a case.
But they cannot.
After the FIR, most probably police made an inquiry, and then it was found that it is a case of defamation. So they accordingly report was submitted before the
Yes,
magistrate, on the basis of which only the cognizance was.
Cognizance token. But this section says that there should be a direct complaint before the magistrate, Lordship, by the aggrieved person, Lordship. May I read 199, Lordship, CRPC. May I read, Lordship?
No, it's okay. I have seen the order sheets also that they are remaining absent, in fact. So now, is there any stay was operating?
Stay is operating. Otherwise,
Stay was operating. So in cases that is stage of what stage? After cognizance, it appearance stage still.
Still appearance and stay is operating.
Stay is operating. কিবা নাই নেকি তেওঁলোকে কৰিব পাৰিম কমপ্লেইন এটা আছে
তারপরে কি নাজানো
Mr. Hussain, what we'll do, we'll give a notice now. If the board is report, if any counsel comes, then it's okay. Then otherwise we may take up the matter at a Monday or Tuesday. You may submit these things, the judgments now. Obviously, it is a complaint, should be a complaint. That is understood. But whether this complaint which was received through police
or direct
will cause any death. That is the only issue.
Only. Yes.
Okay, we're just now giving a notice. At 2, let us see. If they appears, it's okay. Otherwise,
Lost.
At 2 will be. Notice. You have both the parties are ready.
It's up to your lordships, my lord.
Pardon?
I am appealing for the petitioner, my lord.
Yes, you're for the petition.
Yes.
You're for the respondent. Now I'm saying both the parties are ready.
Yes, yes.
Okay, then we'll take at 2. Now it's
Yes.
already 1.
Yes, madam.
So we'll take up at 2.
Yes, my lord.
Them into put up the side of our get what am we saying? Hey, Bora. Oh, she is not here. One instruction she has to bring. No, Miss Bora Bora. No, it's okay. Hey, Bush, it's okay. No issue. Aru put plus level. Bush. Yes, you want to submit it.
Madam, item number 42, my lord. I've been newly engaged in this matter yesterday, man. So I had some personal difficulty today, my lord. Can the matter be fixed after the day after tomorrow, the next week, man? The other side of the council is there.
Who is the counsel of the other side? You are for the respondent. You're for the respondent.
I'm for the petitioner in this case, my lord, but they have filed an IA, but I'm for the respondent, man.
Otherwise, you are for the petitioner.
Man.
Yes, he is seeking time because newly engaged. Okay.
Can be fixed on the second week of May, man.
You're Mr. Chaudhary, na?
Man.
And
S. Khan. S. Khan. On behalf of Mr. M. Hussain.
S. Khan on behalf of Mr.
M. Hussain.
Hussain. M. Hussain. Submitted by Mr. Chaudhary that he has been newly engaged in this case and according to the legal accommodation. Prayer allowed. May not be Monday, Tuesday. There are many matters. I don't know.
My lord.
Can be.
Second week of May, my lord.
11th of May will do. Is there any stay is operating? No.
Yes, there's a stay order.
Stay operating.
The interim order passed.
11th of May, interim order filed will be continued. You have filed the IA, na?
Yes, my lord.
Okay, we'll listing it on 11th of May.
Obliged.
You are looking one this year, na?
Fine.
What?
Item number 18, my lord, we made communication with the, my lord, the jurisdiction police stations, my lord, through our office, my lord. My lord, yet not we didn't receive, my lord. So we pray for a small accommodation, my lord. In the meantime, we will place the, my lord, that is the status of the, my lord, notice.
Through police
Mr.
station.
Khan was appearing now. You're appearing.
Yes.
Your good name?
Police station.
S. Islam.
Heard Mr. S. Islam, the learned counsel for the petition.
Oh, police station.
Also heard Mr. K. Bush, the learned petitioner, the appearing on the state respondent. It is submitted by Mr. Bush that he tried to make an that the no intimation is received from the concerned police station in regards to the service of notice to the respondent. Accordingly submitted that some little that little accommodation may be provided for the same. In view of this, let the matter be listed. We have otherwise we have received this scan copy, na?
My lord, my lord.
This
The 18, my lord.
In view of this, let the matter be listed. When also when it can be?
Yes, my lord, my lord, next week, any date, my lord. Any date.
6th of May. Okay.
6th of.
6th of
May.
6th of May, he is in custody.
More than 100 days.
We'll see to it. That's why I'm just. Monday, Tuesday, both. You correct the intimation.
Can it be
Monday, Tuesday?
30, Your Lordship?
Wednesday. Okay, then Wednesday, next Wednesday.
Ma'am.
Wednesday will be 29.
29.
All right.
Yes, 37. This
Yes,
scan
ma'am.
copy has been
Yes,
sent.
my lord. My lord, scan PCR receipt, my lord. Only, my lord, there, my lord, whenever I have done through that, my lord. This, my lord, there is the CD part is not available. Other than that, my lord, search is there. And my lord was pleased, it is a second bail application, my lord.
No,
My lord was pleased to, my lord, reject the prayer of the present accused petitioner, but allowed to, my lord. And my lord, with a direction that, my lord, in view of the above, all the petitioners are hereby directed to approach the learned trial court for their regular bail. My lord, whenever I have gone through the, my lord, order sheet of the learned, my lord, there is the committal court, my lord. There I find, my lord, that, my lord, there is the to whom the, my lord, the interim protection were granted by your lordship. They appeared and they have given the absolute bail. But, my lord, regarding these petitioners, my lord, they didn't appear, my lord, approach, my lord. And there is no ground, my lord, no new ground at this stage, my lord. And my lord was pleased to, my lord, reject this bail application on 13 to 2026. They didn't appear, my lord. I didn't, my lord, get anything there, my lord. Only, my lord, one order is there, my lord, 27 to 2026. Where, my lord, that is, my lord, the, my lord, the learned trial court was pleased to, my lord, grant the, my lord, bail to those, my lord, to whom, my lord, there is the interim protections were granted. And, my lord, at this stage, summons issue. That is the position of the case.
We'll do one thing. Today, I have some other work also.
Yes, ma'am.
So let the matter be listed on 29th.
In the meantime, my lord, CD may be called for, my lord. Because, my lord, case diary part is not available.
It has to come from which place?
My lord, it is from, my lord, the my lord, it is from, my lord, Nagaon, my lord. My lord, it is in the court of, my lord, the judicial magistrate first class.
For you, the CD will be required?
If, my lord, will go to the merit of the case. Otherwise, my lord, that is, my lord, the status of the case is there.
Status is already there.
Status is already there, my lord. It is in
And
the, my
what
lord,
is the
very, very
status of
initial
the
stage,
case?
my lord.
Whether is there any evidence is already recorded, any prosecution witnesses? No.
My lord, no, my lord. It is in the, my lord, just, my lord, that is the summon issued.
Oh, acha, acha. Okay.
Summon issued. And they didn't appear, my lord. Though there is a direction to appear before the learned trial court, this petitioner did not.
See, I cannot say at this stage whether merit will be, but there is some matters in this because obviously it will be 37 or what? NDPS matter or what?
No, not NDPS.
Acha, not NDPS.
Not NDPS.
So merit perusal of CD may also be required. I cannot say at this stage.
Right.
Also, one
If
humble
it
submission.
reaches, then it's okay. If it doesn't reach, then we'll go by the case diary.
Right.
Case diary. That will do.
My prayer was never been rejected, Your Lordship. On the last occasion when we came for the anticipatory bail, Your Lordship, our other petitioners was not rejected, Your Lordship. Only 2 were granted interim protection. In the meantime, during the pendency, the charge sheet was being filed, and all were being directed to appear therein. The 2 that were being interim order was being given by this court, they appeared before, and we have admitted in my petition that we have not appeared because 118 subsection 2 is involved therein. And there is a life in prison. There is an embargo that they may be apprehended on that section, Your Lordship. And that reason we have not appeared and we have come before this court, Your Lordship. But our earlier bail application was not rejected, Your Lordship.
Hard Mr. S. Done contributed petition. Mr. K. Bush, the United States be obtained on the hospital. Scan copy of this has already been seen, but it is submitted by Mr. Bush that the CD is not available. The scan copy of the CD is not available along with the record, and which may be required for the to consider the merit of the case. In view of this, the registry is hereby directed to make a reminder to the learned court below to send the scanned copy of the CD immediately on or before the next date. We may list it to Wednesday, but I don't know whether it will
Right.
reach. Possibility is less. That's why I'm asking. Can it be on 4th? Okay, 4th of May. And if it doesn't reach also, then we'll go by the other.
Yes, sir.
Time beginning. Anxiety. Other than কোনটো notice আছিলে?
Problem.
So we have given the notice. But in spite of that, they have not appeared. We'll do one thing. Heard Mr. M.K. Hussain, the learned counsel for the petition. None appears on call for the respondent. Heard Mr. K. Busha, the learned petitioner PP, appearing on behalf of states. From the orders, from the record, it is seen that in the 2 of the 3 consecutive dates, the respondent side remained absent without any state. Remain absent, and though the names of 4 councils has been 3 councils has been reflected in the contest. Today, the notice was also given in the display board for their information, but in spite of the information, but in spite of that, none appeared publicly represented the respondent. In view of this, will the matter be listed? Goodbye, Wednesday we are listing it, and you provide the judgments and all in that regard if there is any. 29, we are listing it on 29. 29 4, so and so. And in admission column and in absence of the respondent, consequential order will be passed.
Interim may complain, Lord.
Interim was there, interim may continue being listed. Correct, analysis going on. বইতো আমি অলপ ইচ্ছা কৰি লৈ আছো হ'ব yes 40
This case followed this is NI matter, my lord, they filed revision, my lord.
From the last order, it reveals that an amount of rupees 1,45,000 is already paid and accepted.
Yes, yes, Your Lordship. We have paid.
Now what is your position?
Your Lordship, we could manage the amount for this date.
What is the remaining amount?
Remaining amount of 1,05,000.
1,05,000
is pending. We will pay it on this date. We could not arrange the amount. We will pay it as soon as the amount is.
No, how as soon as there these cases of
Yes, Your
this
Lordship.
revision petition is of 2020.
Yes, Your Lordship. But the petitioner is suffering, so he is unable to pay the amount.
Initial order
that is your-
2017 initial. order, 9 years.
Then what to say is
Your Lordship, we have been.
they also agreed to receive the payment in installment basis.
Yes, Your Lordship.
But in spite of that, only if you now
He is facing financial hardship, so he is unable.
financially we are
Right.
all are first facing financial
Your
hardship.
Lordship, we will make sure on the next, we'll pay within this short period of time, we will.
Just
arrange,
tell us, we'll fix it and in that manner only.
On 5th of May, by 5th of May, we will pay, we will try to pay as much as we can.
If you try to pay by 5th of May, then let it be after 5th of May.
Okay.
So that we can at
In
least.
meantime, we will pay, we are taking money receipts from them. If amount is arranged, I'll just provide them and they will give us, furnish us a money receipt.
We have not furnished any money receipt.
We have received, we have
Then-
those
then
money
what do you
received for the next amount. We are,
Yes, you pay the amount.
yes, Your Lordship, we will pay, we will.
So as per you, the remaining amount is 1,05,000.
1,05,000.
It's okay?
It's okay, but since some strict
Yes,
direction is required.
obviously.
Otherwise, some penalty should be given, fine should be given.
Heard MS RR Mujib, the learned counsel for the petition. And also heard Mr. A. Chaudhary, the learned counsel appearing for the response number 2. And Mr. P. Botafu, the learned additional PP appearing for the state respondent. It is submitted by MS Mujib that due to some financial hardship, the remaining amount of rupees 1,05,000 could not be arranged by the petitioner. However, within a very short period, they are trying to make the payment of rupees 1,05,000. Accordingly, it was links to that in that regard, Mr. Chaudhary, the learned counsel for the response number 2, submitted that strict direction should be given to the present petitioner as the matter is pending since 2017. Until date, there's no, the entire payment is not been made. So, in view of this, and consider, view of this, considering this next paragraph, considering the submission made by learning counsel for both the parties, the petitioner is hereby directed to make the payment within the shortest possible time. And the petitioner, respondent will also issue money receipt to that regard. Let the matter accordingly be listed in the order column on 11th of May. Then, if you can provide it by 5th
Yes,
of May, then it
yes.
can be fixed on 11th.
Yes.
Okay, we have fixed it in, but rest assured that
Will pay.
payment should be there. Okay. Because they are considering your problem and the
Yes, sir.
payment
Yes,
it has
yes.
already gone.
Definitely.
Yes,
definitely.
Yes. So 11th of May. We are listing it on 11th.
Yes, sir. Obliged. Lordship, the service report on respondent number 2 is awaited, Lordship.
Respondent number 2. But on the last occasion, most probably, oh, now you have already sent to through officer in charge.
Lordship.
Still awaited, no? You are MS?
D. Mohanto, Lordship.
Heard MS B. Mohanto appearing on behalf of the petition. Also heard Mr. A. Busher, the learned additional BP appearing on behalf of state respondent. As per office note dated 20/04/2026, the service is still awaited for the respondent. Your address is correct?
Lordship.
It is seen from the order that the petitioner was asked to take step, the respondent number 2, through officer in charge of the concerned police station. Till that, no report has been received for the respondent. Let the next one, let the service be awaited till next date of listing. Yes, for when it can. 13th of May.
Lordship. Lordship, there is an interim order. Maybe.
Interim on 13th of May, interim be continued.
Much obliged, Lordship.
My lord, 43, my lord, they have taken the, my lord, there is a service state. But my lord, it is through the, my lord, directly speed post, my lord, not through the office of the public prosecutor. Yeah, my lord, it is reflected in the, my lord, office note, my lord, POCSO matter, my lord.
Oh, why
So, my
you
lord-
have taken it? It is ought to have been through
Yes, my lord.
registry
So,
and
my lord, again, my lord, they take a fresh step, my lord.
I'd like to
take a fresh
Take
step.
a fresh step, my lord. Yes.
probably it is
In that case, it will be easier for them
My
also
lord,
to
my
track the
lord, my
Yes,
lord,
yes, yes.
my lord.
probably a mistake done by clerk.
much. Heard Mr. G.O.D., the learned counsel for the petition, also heard Mr. K. Bush, the learned additional PP appearing on the respondent. It is submitted by Mr. Bush that the The steps on the respondent number 2 was taken directly through a speed post and not through the proper procedure, or not through the office of the public prosecutor or the office of the registry. In view of this, Mr. Uddin submitted that he will take fresh steps on the respondent number 2. Accordingly, the petitioner is hereby asked to take fresh steps on the respondent number 2 through office of the public, through registry and the office of the public prosecutor. Steps will be taken within 3/4 days from the date. And we need the scan copy.
Scan copy receipt.
Scan copy
Already
receipt.
received. Scan copy of the scan copy of the DCR has already been received. This the matter.
First
But-
week of May.
First week of May will not come.
Well,
First week of May it will not come.
second week.
After 2 weeks we'll do without fixing any date then. Let it be
13 May.
You want fixed date?
Fixed date, my lord, I want, because I have to, otherwise I have to make mention.
Okay, then.
13. I'm obliged.
May I plead the lordship, my lord, this is an application under section 528, my lord, praying for quashing of a proceeding before the learned trial court as well as the impugn order at page 58, annexure 8, my lord.
Yes, justice.
The complainant is absent with steps by petition number so and so which is allowed. Opposite parties are present. Today is fixed for order. The instant case was instituted on the strength of Naraji petition against the FR submitted by the concerned IO of Borsuk PS. The complainant have alleged that the accused persons have cheated them and through forged documents and false pretext. So your lordship may
Against which order you have said? Is it
Against
petition for quashing or
yes, my lord. Petition for
entire
proceeding, my lord, as well as this particular order at page 58.
particular address order is at page?
58, my lord. Annexure 8.
Yes. By this order, the impugn order, what the order was placed, cognizance was taken.
Yes, my lord. So the facts of the case, my lord, is that, my lord, the petitioner, he was the possessor of a particular plot of land. One Yatir Pabin Bara, she approached the petitioner for purchasing that plot of land from the petitioner. And then, my lord, the petitioner executed one possessory right sale deed that your lordship will find at annexure 1, page 13. So the case starts from there, page 13, annexure 1. This is the translated copy, and original one your lordship will find at page 15. So the petitioner number 1 is the possessor of a particular plot of land. So he sold the possessory right of that plot of land to Srimati Yater Pabin Bora. And for that purpose, the petitioner number 1 received some consideration from Yater Pabin Bora. So this annexure 1, page 15 is the original possessory right sale deed. So this is only possessory right sale deed. Since it was not a Miyadi Patta land, so
Possessory right was.
yes, my lord. So thereafter, what happened, my lord? The petitioner, my lord, she was not even the purchaser of that plot of land, possessory right, my lord. The petitioner filed a FIR before the Gorsuk police station that your lordship.
Petitioner means respondent here.
Yes, my lord. Sorry, my lord. Complainant, the respondent. Yes. She filed a FIR before the Gorsuk police station at page 23, my lord. Page 23, my lord.
Dear sir, madam, on the very outset, I extend my so-and-so. I, Miss Pompi Bora, daughter of Apurva Kumar Bora, resident of Gauhati, Assam, would like to state certain facts and circumstances of my life which led to immense trauma, hardship, financial loss, mental agony, and harassment to me and my family from the society at large. I am the only earning member of my family at present, trying to lead a simple life, so-and-so. Then next paragraph, my father, Sri Apurva Kumar Bora, a retired person from the government of Arunachal Pradesh on 31/2011, received the retirement benefits from the government which amounted to rupees 8 lakhs. Expecting to have a well-establishment at Gauhati, Assam, my parents decided to stay with me as I am doing a small private job at Gauhati itself. Depending on me, they arrived Gauhati. At that time, a best friend of mine, Sri Nekibur Rahman, that is the petitioner number 1, my lord, so-and-so from my college days had proposed me and my parents to buy a piece of land belongs to him situated at Posim Boragaon, Gauhati, so-and-so. I, being the eldest, took the initiative for buying this piece of land from Nekibur Rahman for building a small residential house for my family. Discussed with my parents and a fair discussions with Nekibur Rahman and Jili Uzir, I purchased 1 kotha land in my mother's name, that is Yater Pabin Bora, from him and his wife Dili Uzir for an amount of rupees 5 lakhs on dated 25/5/2011 from my father's retirement money in a good faith, as both of them were very close friends to me from my college days. And Jili Uzir is the petitioner number 2 here in my lord. Herself is lower. So the question of doubt never arose between us. The entire amount of rupees 5 lakhs was handed to Nekibur Rahman and his wife Jili Uzir. Rupees 3,60,000 by cash and rupees 1,40,000 was deposited in Jili Uzir's account of SBI Bank as desired by Nekibur. Her account number is so-and-so, where we have deposited the said money. Enclosed where is the deposited slip, so-and-so. At time of making the payment, Nekibur Rahman had prepared the agreement papers and proper document from his side in a very manipulative manner and succeed to convince us that it was actually a sale deed and our entire transaction was now legal. We had no idea that he fraudulently robbed our money. It was realized by us only when a team of people from government came to evict us from the said plot of land, as that land belongs to our government. We hardly realized that we were very gravely seated by Nekibur Rahman and Jili Uzir. Still, I still fail to understand how someone can be so ruthless and cruel to innocent people like us. So, my lord, from the annexure 1, it is apparent, my lord, that that was a government land, that was not a Miyadi Patta land. And it has been clearly stated therein that that was a document for sale of possessory right only. So, the sale of possessory right, Dokhol Mati Bikri Patra. So, one person when purchases a government land, my lord, always there a risk of eviction in future. So that has happened to the complainant, my lord. So just after the first eviction on March 12, we had a meetings with the societies of Posim Boragao peoples, including all the secretaries. The society members advised us to pay an amount of rupees 58,000 to Mr. Adil Shah, a renowned person, for a favorable and desired result against that piece of land. We paid him the amount of money coordinating with the people of the society for getting the absolute ownership right to our plot of land. The society people were as some Muslim Khan, Mr. Ziadur Rahman, Inu Begum, Amjad Bora, etc., in which our plot of land was situated. But 1 year left by nothing happened in our side. Just everything was seen as an hanging breeze. So, my lord, from this also it is clear that they purchased that plot of land knowing that that was a government piece of land. Subsequently, they took steps with some other person for making that Miyadi Patta, my lord. Otherwise, for an amount of 5 lakhs, my lord, 1 katha land cannot be purchased in entire Gauhati city, my lord. So only because that was a government land, they purchased only the possessory right for rupees 5 lakhs. And thereafter, they took steps with other persons, my lord. for making that land Miadi Patta land, my lord. Just everything was seen as an hanging bridge. Mr. Adil Shah promised us to hand over all the proper papers establishing our absolute ownership over our plot of land that we brought from Nekibur Rahman. But Adil Shah was like as Nekibur Rahman and Jili Wazir, as whenever approached him, he refused to give back our money, so and so. He even don't receive our phone calls, and when I went to his office, he ill-treated me and turned me out of his office. In the meanwhile, for the second time, that plot of land was again evicted by the government. Today, we are totally demoralized by all these fraudulent activities. So, my lord, apparently, from this complaint itself, it is clear that they knowingly purchased a government plot of land. Thereafter, they took steps for making that plot of land Miadi Patta land. When they failed to do so, and in the meantime, eviction was carried out. Thereafter, they have filed this complaint. And on the basis of this complaint, a police case was registered, my lord. Bhait Gorsuk PS case number 194 of 13. And police duly investigated, and thereafter police submitted the final report that your lordship will find that page 27 annexure 3 final report. And relevant portion of the final report at page 31, my lord.
Page 30.
Page 31, my lord. Page 31. On investigation, the previous IO visited the place of occurrence and drawn up a sketch map and examined the witness and recorded complainant and available witness statement under section 161 CRPC. On inquiry, it was known that the matter was civil dispute. And accordingly, I have submitted final report as the matter was civil dispute and the case diary has sent to the Honorable Court. So the investigating authority has rightly, my lord, pointed out that it is a civil dispute and they submitted the final report, my lord. Then, my lord, annexure 4, page 32. The order dated 71/2025 passed by the learned SDDM 1. Thereafter, the complainant filed one petition before the learned trial court, my lord, against the FR. And accordingly, by this order dated 17/1/2025, it has been directed to register a complaint case. So after registration of the complaint case, my lord, the petitioners appeared before the learned trial court and submitted
Which order of cognizance is that page?
page 58, my lord. 58, my lord. So basically, my lord, the ground cited in this petition is that, my lord, it is a civil dispute. And never the petitioner has cited the complainant, my lord. Because from the very case that starts from the possessory right sale deed, which clearly states that, my lord, they have sold the possessory right only. Because that annexure 1 possessory right sale deed, if I read in the Assamese portion, my lord, শস্য জমি দখল বিক্রিপত্ৰ মৃদং কাৰ্যকালে আদি মোৰ টকাৰ বিশেষ আৱশ্যক হোৱাত মোৰ চুক্তিপত্ৰৰ পৰা এক কঠা জমিৰ দখল বিক্ৰী কৰাৰ কাৰণে পেজ 15 মাইলৰ জমিৰ দখল বিক্ৰী কৰাৰ কাৰণে প্ৰস্তাৱ কৰাত বৰাবৰেও খৰিদ কৰিম বুলি সন্মত হয়। So my lord, specifically this deed was executed for sale of the possessory right of the petitioner to the mother of the complainant. So no fraud has been committed, my lord. There is no ingredient of any criminality, my lord. And at that point of time, the complainants and their family, they also they purchased the possessory right. Probably that time they thought that in future they will regularize the land, my lord, by paying the required government fees or other procedure, my lord. They will make the land Miyadipata land. But when they fail to do so, and for that purpose, they have paid some amount, further amount to some other persons also, which itself has been stated in the FIR, my lord, as well as in the complaint. When they failed to do so, in the meantime, government evicted them. They filed this complaint, my lord. And that too, my lord, the complaint has not been filed by the concerned party, my lord, Srimati Yate Parveen Bora, my lord. It has been filed by one Pompi Bora, my lord. So this is a small issue, my lord. Your lordship may decide whether any criminality has been committed by the petitioners or not. Prima facie, what criminality they has committed, what offense they have done, my lord. Your lordship may examine that, and thereafter your lordship may pass necessary order. That is
May
my
I
humble opinion.
My Lord, Pompey Bora, who is the respondent in this particular case, as well as informant in the FIR and complainant in the complaint case, CR case number 55, is the daughter of Yatir Pabin Bora. Yatir Pabin Bora purchased the land. She is the mother. And after purchasing the land from the petitioners, petitioner number 1 and 2, Yatir Pabin Bora, when took the possession of the land, she was well aware, it is not a denying fact that she knows that she has bought the possessory right of the land only. And she signed the Kacha deed also. After signing the deed, she went to take the possession. But she never was able to take the possession of the land because she was not allowed to enter into the premises for a single moment. She immediately went to the nearby police station. That
Who forbidden her to enter into the place?
The police people, because already eviction was going on. When the deed was executed, it was well prepared by the petitioner number 1. And when she signed the document, after signing the document, this depositing 5 lakhs amount of money to the petitioners, she went to took the possession to build a house on that particular land. Now here, petitioner number 1 and 2 are very well known people to her daughter, that is Pompey Bora. Pompey Bora used to study with petitioner number 2, Giliuze. She was her college mate, studied together, stayed in the same hostel, and then they shared the same room, everything. So there was a trust thing that was going around when petitioner number 2 directed Pompey Bora, the respondent herein, to purchase that particular land from her husband, Nikibur Rahman, the petitioner number 1 here. She agreed to purchase it on basis of trust because it was not a one-day affair, but a long-term association where the trust was built between the respondent and petitioner number 2. So she purchased the land, and after purchasing the land, she went to took the possession. But the moment she entered into the premises, she was not allowed because eviction was already going around. She went to the nearby police station, Gorchuk police station, and on behalf of her mother, Pompey Bora, the daughter, filed the FIR. But the police did not took any action on that particular FIR for a very long period of time. Approximately, she ran to the police station for nearly about 1 to 2 months, but no FIR was lodged. Finally, she wrote a letter to the Prime Minister office. The then Honorable Mr. Manmohan Singh was the Prime Minister of our country. So she wrote a letter to the Prime Minister, and then from the Prime Minister office, a direction was given to lodge the FIR to the SP office, and a FIR was lodged by the Gorchuk police station. After the FIR was lodged, she went to petitioner number 1 and 2 to discuss the thing that you have fraudulently taken away my money. It was the money of her husband, Yater Pabin Bora's husband, that is the father of the Pompey Bora, who was just retired from his government job. It was his whole time, lifetime investment. And with that money, they had purchased that particular land without duly verifying on basis of trust that was built on petitioner number 2. So after that happened, they went again and again to meet petitioner number 1 and 2, but they denied that you have already signed the document. We will not return you any kind of money. After that, it took 10 years, 10 long years, because the FIR was lost in 2013. And in 2023, the FIR was submitted by the Gorchuk police station. After 2023, when the FIR was lodged by the Gorchuk police station, the the respondent filed a complaint case, case number CR 55 of 25 before the learned trial court for taking the cognizance of the matter. Duly notice was served and hearing was done. Now, Your Honor, the cognizance was taken on 11/3/2025 and not on 23/5/2025. Page number 70.
They have submitted the.
Yeah. Yes, my lord. Page number 70. Affidavit in opposition, page number 70, annexure 1. Dated 11/3/2025. The last part. I have heard learned counsel for Nekibur Rahman and Jili Uze. After hearing, I deem it proper to take cognizance and examine the complainant under section 223 BNS. So cognizance was already taken on 11/3/2025, not on 23/5/2025. That is page number 58, as submitted by the petitioners. The hearing was done on 11/3/2025, and on the same day, the Honorable Trial Court took the cognizance on this particular matter. So in this respect, the prayer submitted by the petitioners to quash the order dated 25/5/2025 is infectious because already the cognizance was taken on 11/3/2025.
So 2025.
The impunity.
25 is in which page? Order dated 25.
23/5/2025. It is on page number 58. Page number 58, annexure 8, submitted by the petitioners, dated 23/5/2025.
And where from you are saying that on 11/3 cognizance was.
It is page number on page number 70, annexure 1, submitted on the affidavit in opposition. Page number 70. Order dated 11/3/2025.
How it is? How?
My lord, 11/3/2025, the petitioners appeared before the learned trial court. They submitted their objection, my lord. So after that, my lord, after considering their objections, my lord, the notices were issued to the petitioners on 23/5/2025. So initially, your lordship may peruse the order dated 23/5. Because
Notice
order
was
dated,
already issued earlier,
no,
my lord.
it says, my lord.
Because on that
issued
particular
summons
day,
against so-and-so.
Nekubur Rahman and Jeliuzi's council did the hearing. It was mentioned, it is reflected in the order itself. In the last part, I have learned council
And
to
my lord,
Nekubur Rahman and Jeliuzi.
Annexer 50, Annexer page 58, after going through the relevant complaint petition, statement of the witnesses and documents, I deem it proper to take cognizance against the accused persons under so-and-so. Page 58, the order dated 25th. Because initially, my lord, the notices were issued to the petitioners. They appeared before the learned trial court. They filed their objections against the petition. Thereafter, by the order dated 23/5/2025, the paragraph number 5, my lord. So, after going through the relevant complaint petition, statement of the witnesses and documents, I deem it proper to take cognizance against the accused persons under section so-and-so, so-and-so. Your lordship has got it? Yes, my lord. So, thereafter, my lord, and subsequently last para, issue summons against accused Nekibur Rahman, Dili Uzir and Muslim.
23/5/2025 is the order of taking cognizance.
Yes, my lord.
And 13/11/2025, it was notice was issued
Yes.
for pre-cognizance hearing.
Yes, my lord. Pre-cognizance hearing. Yes, my lord.
Pre-cognizance hearing was made on that day and order was also passed on that day itself. Because the order says, notice issued to the opposite party, namely Nekibur Rahman, Jili Uzair, Muslim Khan, had been properly served. Learned Counsel B. Pal has appeared on behalf of Nekibur Rahman and Jili Uzair. However, Adil Shah and Muslim Khan so-and-so. From the postal report, it appears that the Adil Shah has passed on so-and-so. Notice was served on Muslim Khan so-and-so. White petition number 7542 complainant stated that individually omitted to mention the name of accused Eliuzi, Muslim Khan and Adil Shah in the protest petition has prayed for allowing the complaint to insert their name. Pertinent to note that the FIR was registered against the aforesaid accused person and primarily allegation in the complaint are against the accused. Therefore, the prayer for insertion their name are allowed. This is one part. And I have heard learned counsel for Nekibur Rahman and Jili Uzair. The hearing was already done that day, that particular day. After hearing, I deem it proper to take cognizance and examine the complainant under section 223 BNSS.
Yes.
So
That is one
cognizance
part.
was already taken
Take
at that
cognizance.
No, under
Yes.
23 cognizance hearing was fixed.
Yes, my lord.
It's
Your lordship
writing a
is
bit
right.
different, but for cognizance hearing only under 223.
Yes. And
BNSS.
cognizance against the accused or petitioners is by the order dated 23/5/2020.
It seems to.
Yes, my lord. Because that is cognizance and take cognizance and examine the complainant under section 220. But
Anyway,
cognizance.
whatever cognizance was taken.
Yes, my lord.
After hearing the both sides, giving an opportunity of pre-cognizance hearing, the cognizance was taken.
Yes.
Now they are against the
cognizance.
Yes.
But cognizance against the accused is by the order dated 23/5/2020.
Yes. So whatever on 11/3 the notice was served.
Yes, yes,
were
madam.
heard.
Yes, madam.
And the date was fixed on 23.
And otherwise also I have challenged the entire procedure also, my lord. Yes, madam.
So that is one part. And what
That
is
is
the
one
other
part.
position?
Now, the instant matter says that since it is related to some land, axona plot of land, so it is purely civil in nature. So no criminality is attracted in this instant matter. And so the petitioners want to quash this entire proceeding. My humble submission before this court is that the case is criminal or it is civil, no denying fact. But whether it draws the criminal part is a matter of question here. What about the mens rea, that is the guilty mind of the petitioner while selling the plot of land to the respondent? The mens rea, which is an integral part for drawing any case as a criminal case, is very much important in this particular matter. The petitioner number 1 and 2 were well aware that this land may got evicted any moment, any time. Without informing this important integral part to the respondent, not for a single time, they sold the land to the respondent, taking away rupees 5 lakhs of money, which is a wrongful gain. Now, this is a purely criminal intention. There is the criminal intention lies from the beginning of this entire proceeding before signing the deed of possessory right. They have the deception in their mind to deceive the respondent with this amount of money. A breach of trust involved there because they were close associated people. She was quite aware, petitioner number 2 was quite aware of the fact that whatever I will serve to the respondent, she will easily agree to it because it is a matter of trust. So there is a breach of trust. There is deception on part of the petitioner number 1 and 2. There is dishonest inducement. By inducing them, they have sold a possessory right to the respondent. And there is the the loss that the respondent had suffered due to the criminal and fraudulent nature of the petitioner number 1 and 2. These are all matter of evidences which could be possible for if the trial matter proceeds. In the evidence stage only, the respondent will be allowed to produce any document if she had. Now, there is an important question. She purchased the possessory right. It is not a denying fact. I do agree that the possessory right was sold. Whether the petitioner number 1 was in the legal capacity to sold that possessory right to the respondent is a matter of question, which is a purely criminal nature.
How?
Because whether
Now see, there are many lands which are going, the possessory right has been sold, especially the Exonia. And by giving some premium and all, it can be turned to a mere land. So why you are saying that it's a criminality? How? And you agreed to purchase the possessory right. So how criminality was there?
Because whether he was in the possession of that land or not is a matter of question, my lord. Whether
he was not in possession of the land.
He was not in possession of the land, that the land document will verify, which will be which we will be able to produce in the stage of evidence.
Follow you.
Even if admitting, accepting her statement, before executing the deed, my lord, she should have verified possessory right.
You want to say that they were not in possession?
No, I am not saying that they were not in possession. I am saying that whether the criminal intention lies to sold that particular land to respondent or not, that could be verified from the document also. I am saying that the criminal intention
What
is
kind
always
of document will help you?
With the help of documentary evidence.
What kind of document?
If the Sitha and all reflects
It's a
somewhere.
government land. How there will be
Government land.
It's a government land. That means he could not sold it.
Land.
That means he could not sell the possessory right also. If I am purchasing the possessory right.
That's what I'm saying, that the possessory right actually could not be skipped, cannot be said, but these things are going on. That is properly Mati.
Yes.
That is there.
Yes, ma'am.
So it is not at all it's still government land. So one what they say, that it has to be paid to the government also if you possess that land. These things are there.
Revenue.
So yes. So in that case, prior to purchase of your land, have you verified all these documents?
No.
Suppose if the documents are there or documents are not there, then how can you say that it was a criminal intention?
That's what I'm saying, my lord. In the evidence stage only, no, we can verify this thing because we cannot produce everything. Since we have to accumulate those things, and they will also get a fair chance in the evidence stage only to prove whether the land they gave us to as a possessory land was actually he was in the legal capacity or not. And moreover, it is purely a kind of the fraudulent nature was there from the beginning of the entire process. When before beginning of the entire process, they have already decided that we will sell this particular land to this person because they will trust us and we will take the money. And then they will be soon evicted because they know, they were well aware that the eviction might be happening anytime, in any recent time. So when they sold the land, the eviction was just happened immediately. That means they were quite aware that the eviction will happen and she will not be able to get the land for the possession also, build a house or whatever. So they will not get the chance. So deception, wrongful gain, and dishonestment, inducement, fraudulent, these are all criminal actions which were committed by the petitioner number 1 and 2 by selling this particular land to the respondent.
Yeah. Yeah. Yeah, people want to like, well, I'm very Get your head. Delivery for delivery order देखिए हाल मीटिंग কোনো আছে এটা আধারিত হয়ে my intention was to dictate the petition now itself, but I have someone meeting also.
Yes,
Anyway, we'll deliver the order on Wednesday.
yes, madam.
Delivery of offer on Wednesday.
Wednesday. তুমি একো কৰিব না।
It area falls under which area? This is
My lord, it is
Boragaon,
Gorsu, under Gorsu
Oh,
police station.
Boragaon, Gorchu police station.
Gorsu.
Just a few kilometers away from the Gorchu police.
false. It's very important.
Oblige, my lord.
Obliged.
Honestly. Item number 13,
Lordship,
yeah.
we have filed the IA for the modification of the interim order, like.
For vacation of the interim order.
Yes, unfortunately.
Till when, since when the interim order is operating?
Since 9/1/2026, Your Honor.
This year only?
Yes, Your Honor. Unfortunately.
And what is the stage of the case before the trial court?
It's still in the stage of appearance, Your Honor. The cognizance has been taken and it's still in the stage of appearance.
At the stage of appearance, you have come with a
Yes, Your Honor.
question.
Yes. Yeah.
So is there any urgency of this vacation of the interim order? I mean, you have filed the IA for vacation of the interim order, isn't it?
Yes. My, actually, my lord, like, due to my senior name, like, has not appeared costly, so we have missed the item.
Your senior is?
Embora.
Embora.
Yeah, so Lordship kindly
So
grant for
basically,
adjournment.
you are for the respondent otherwise. You have filed the IA also, but you are for the respondent.
Lordship.
Criminal petition for na Embora, na?
Lordship.
You are MS?
S. Aziz, Your Honor.
Huh?
S. Aziz.
S. Aziz. Particularly, heard MS S. Aziz, Legal Counsel for the petition. Also heard your good name?
L. Tonger.
L.
L. Tonger.
L. Tonger, Learned Asaram Counsel for the respondent. However, it is submitted by MS Tonger that as the name of the NPS counsel, Mr. M. Name of the NPS counsel, Mr. Embora is not.
Miss Embora is Miss Embora.
MS Embora. MS Embora is not reflected in the cause list, so they have not prepared to go for the hearing. Accordingly, paid for a little accommodation. Prayer allowed. Listed when it can be listed then. After 1 week will do.
Yes, 48 we have some problem. From 4 to 8 we have some difficulty, my lord.
From
So
4th
after
of May
8,
to 8th of May.
we have some difficulty, so
14th. In that case, we are listing it on 14th. Till 14th only the interim will be continued. And let's see if it is it may be a case for vacation, it may not be also, we'll see to it. Okay. Or do one thing, 14 May, na? 14 May could be interim be continued till next date. What I'm suggesting, you have prayed for one IA for only vacation, isn't it? but the matter has already been listed for admission column, in admission. So in admission column, most of the matters can be disposed of in admission column itself. So I think better not to go for the IA. Let's concentrate with the main application, that is the petition, criminal petition. We can dispose of it in the admission stage. If it is disposed of in admission stage, your entire petition, then that disposal of the other, your interlocutory application may not arise also. It may be a case for quashing, it may not be a case for quashing. If it is not a case for quashing, then entire case will go. Then your petition, your original case will again will be rejoined and start. No interim will be there. Okay. So on the next day, you just ask your senior to go for the hearing of the entire criminal petition in admission stages on 14th.
Apply.